ಅದು ಸೈನ್ ಆಗಿದ್ರೆ ಇದ್ರೆ ಬೀಂಗ್ ಸ್ಪೋಕನ್ ಟು ಹಾಕ್ಸಿ, ಸೈನ್ ಆಗಿದ್ರೆ ಹಂಗೆ ಇದು ಆಫೀಸ್ ಕರೆಕ್ಷನ್ ಅಂತ ಜಜ್ಮೆಂಟ್ ರಿಲೀಸ್ ಆಗಿದ್ರೆ ಮೆಮೋ ಇದು ಚೇಂಬರ್ಸ್ ಕಳಿಸಿ,
ಚೇಂಬರ್ ಕಳಿಸಿ ಅಲ್ಲ ಮೆಮೋಸ್ ಎಲ್ಲ ಕೊಡಿ. ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಬಿ ಗ್ರೂಪ್ ಮ್ಯಾಟರ್ಸ್. Only B groups. 21 to 26. 21 to 26. Government.
The request of petitioner call on date could. I think
229.
Sir, it's a 2013 matter, sir. And see, Sudhindra is regularly avoiding this court. See, last week also you made similar submission in respect of some other case.
See number?
Friday ಕೊಡ್ತೀವಿ. Friday.
23, 23.
No further time, sir. Have you informed the other side? It's a 2013 matter. Yes.
27 to 30, list 1, 27 to 30 adjournments. 31 to 38, 39 to 45.
Serial number 36, ma'am. Kindly have it tomorrow, ma'am.
Okay.
Why, madam?
Serial number
36.
Why do you want it tomorrow?
My lord, senior is not well, my lord.
3 ದಿವಸ ಬಿಟ್ಟು ಕೊಡಿ.
22. Serial number 39 to 45.
That's serial number 45 and 46, ma'am.
ಇದು 3 ದಿವಸ ಬೇಡ ಹಂಗಾರ. ಸೀರಿಯಲ್ ನಂಬರ್ 36 ಹುಷಾರಿಲ್ಲ ಅಂದ್ರೆ ಒಂದ್ ವಾರ ಹುಷಾರಿಲ್ಲ ಅಲ್ವಾ? ನೆಕ್ಸ್ಟ್ ಸೋಮವಾರ ಕೊಡಿ. 36 ಸೋಮವಾರ ಕೊಡಿ.
27. 27, 8. 36. 45, 46.
ಅದು ಅದೇ ಡೇಟ್.
27, 8. 46 to 53.
My lords, serial number 48, my lords. Further hearing matter, my lords. The arguing counsel is not well, my lords. Some medical emergency is there.
Pradeep Kumar.
We have informed the respondents, my lords.
Okay, when do you want?
Any specific first week of September, my lords. 2nd September or 1st September.
Good.
39.
Deeply obliged, my lords.
Serial number 1, list 1. Ajay Jayan, Monica Patil.
First. The request of notice ಆಗಿಲ್ವಾ? ಆಗಿದೆ ಅಲ್ವಾ? good. Yes. The request of
R3 ಆಗಿಲ್ಲ ಸರ್. R3 ಗಾಗಿ. Is also KDV.
Ms. Monica Patil accepts notice for respondent number 2, 3. Respondent number 3. Yes, the request of respondent number 2 and 3 call on. Where do you want, ma'am?
49 better, 59 ಕೊಟ್ಟು ಬಿಡಿ ಸರ್. 49.
Fine.
Number 2, Sampath K. Krishna.
Objections.
My lord, for petitioners.
Refer to a week's time. Objections are ready. I'll file it in the
What do you want? Mutually convenient date take.
28.
The interim order may be extended.
So the request of respondent number 2, colon 28, interim order of is extended till next date of hearing.
3, Vasant Kumar HT.
Good.
The petition in this case, my lord. The respondent issued an endorsement and annexure J, K, and H, my lord.
Hmm.
The petitioner is the owner of the land bearing survey number 27 measuring 22 guntas, my lord.
Hmm.
Situated at Saram Vishwesharaya layout. Without due process of law, the respondent has acquired my land and utilized Saram Vishwesharaya layout, formed in Saram Vishwesharaya layout. And thereafter, my lord, the Honorable High Court has given direction to respondent to give alternative land in the petition, my lord. Thereafter, the respondent has give the alternative land, and now his marginal land is there, my lord. We sought for marginal land, my lord. The respondent has issued 100% market value in this marginal land, my lord. In similar cases, the Honorable Court has directed to respondent to fix the marginal land, my lord, in the prevailing rate, my lord.
What's wrong in the order passed by the
Fix the
authorities? Note, they know,
I seek inspection and next.
who will appear,
For BS Karthikeyan.
BS
BS
Karthikeyan.
Karthikeyan.
so access notice for respondents. Call on,
Yes, sir.
when do you want? When do you want?
Alerts next week, my lord.
2 weeks with date, good.
copy, sir, my lord.
449.
Objections if any by them.
Number 4, Nishant AV.
I appear for the petitioners, my lords. Here the notification issued by the KIDB under 28.1 and 28.4 are under challenge. My lords, I am only agreed by the 25 guntas of land, my lords, which is notified in survey number 161. My lords may kindly take the annexure K, page 71. This, my lords, is the proceedings which was pending before this court and disposed of. Annexure K, page 71.
Tell me.
The petitioners herein, my lords, claim to be purchasers from my mother. Here, my lords, they had challenged the notification issued by the KIDB, which was notified for Bangalore Metro, my lords. Then, my lords, during the pendency of this petition, there was a compromise entered. My lords may kindly come to page 79. 79, paragraph A, my lords, of the order. There, my lords, this honorable court says 25 guntas of land in survey number 161 of Kengeri Revenue Village has to be furnished by way of security. This 25 guntas of land, my lords, now is again notified by KIDB under the notification. This land, my lords, in view of various suits and litigations which were pending, now they are trying to take compensation of this land also. I am only agreed to that extent, my lords. That is at page 79.
Petitioner mother filed a memo, my lord, before these earlier proceedings. Say that, my lord, 90% amount should be dispersed and 10% amount should be deposited to the court, my lord. Kindly see, my lord, page number 75.
In addition to that, 25 guntas of land was directed to be kept in as security. In addition to that,
So how does it prevent KDB from taking, acquiring the property?
my lords, since this was a part of the order passed by this honorable court, my lords, they should have sought leave of this honorable court before notifying is my case, my lords.
So that note is gone. AGF for R1.
2, 3, my lord, 4, Pradeep, my lord, because earlier occasion, my lord, they are appearing in this proceedings.
2, 3, 4, HL Pradeep Kumar.
5 and 6, my lord, Harish.
Accepts notice. 5 and 6, Harish.
Harish.
Issue emergent notice to
7 to
other respondents.
May I make
14.
one request, my lord, one request. Let the compensation with respect to 25 guntas not be dispersed, my lord. Let it be kept before the
For
court.
consideration of interim
Okay.
rates. Call on next week date. Next Monday.
Addition-
For consideration of interim
And
rates.
in
Let them
addition,
come back
in addition, can I take out hand summons also?
to other respondent.
Other respondent.
ಇದು ಮೇಲ್ಗಡೆ, in addition to regular mode of service, petitioner is also permitted to take out hand summons on other respondents.
Please.
ಅದು ಅದಾದ್ಮೇಲೆ for consideration of returnable by 20, sir. So that's correct.
27.
26 holiday.
27th ಅಂತ ಹಾಕು.
Can I request for 28th?
ಆಯ್ತು, 28th. Call on 28th.
I'm grateful.
So ಒಂದೇ ಸಲ ಡಿಸ್ಪೋಸ್ ಆದ್ರೆ ಆಗ್ಲಿ ಅವ್ರು.
And
ಯಾವುದು? ಆಯ್ತು, ಕರೆಕ್ಷನ್ ಮಾಡೋಣ. ಆಫೀಸ್ ಕರೆಕ್ಷನ್ ಮಾಡ್ಬೋದಲ್ಲ. Direction to any one of the persons is disturbed, to make office correction by Thursday.
Number 5.
But the matter is pending before the Supreme Court.
What is this matter about?
ಸ್ವಾಮಿ ಇದರಲ್ಲಿ
Taking acquisition of data and eight paid.
The interim order is passed.
may I make my submission. Now the prayers that is sought for in the petition is the proceedings, acquisition proceedings with respect to the present layout, which is notified under the final notification dated 19/1/2000.
No, what is the status quo?
Has been-
Have you seen this status quo existing as of today shall continue until further orders?
ಸ್ವಾಮಿ
ಇದನ್ನ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ, ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ರೆ.
ಕೊಟ್ಟಿದ್ದಾರೆ ಇದರಲ್ಲಿ what they say is the my matter was ordered to be listed. Madhu, my matter was ordered to be listed in pursuit, the moment the writ appeal is disposed of by virtue of order dated 16/6/2016. Now the Honorable Supreme Court was, the Honorable, this division bench of this Honorable Court was pleased to hold that the matter has already disposed of in the SLP, that is the 28/3/29 of 2018, that we are bound by that. The findings recorded was the scheme has been lapsed under section 27 of the BD Act. Once the scheme has been lapsed and the finding is recorded on facts, that would be binding on the division bench, since it is the earlier batch of petitions which ended in SLP number 28/3/29 of 2018 is also dismissed. Now they have come up with a plea saying that we have preferred a review before the Supreme Court. That's what they have said. Before.
But status quo order ಆಗಿದೆಲ್ಲ review petition ಅಲ್ಲಿ. Status quo order is there. What can be done? We can't do
I
anything.
beg your pardon, my lords, but what my learned senior selling is submitting, I have to verify that. But as of today, batch of SLPs are pending regarding.
No, these are SLP
This is
only.
with respect to only a particular land which belonged to one Padmamma. The order of the division bench was not, no, the facts is different in this matter. That request to be considered. ಅಲ್ಲ ಸ್ಟೇಟಸ್ ಕೋ ಯಾವ್ದೋ ಒಂದ್ ಯಾವ್ದೋ ಮ್ಯಾಟರ್ ಸ್ವಾಮಿ, ಇದಕ್ಕೆ ನಮಗ್ ಸಂಬಂಧ ಇಲ್ಲ.
There is a batch of SLPs.
Correct, but the SLP 28/3/29 of 2018.
See, I'll do one thing. I'll call it after 3 days. Both of you verify and state.
Yes, my lord, we have verified this. Now, my lord may kindly peruse the SLP order.
Good.
Six to 2023 in writ appeal number 862, passed by the Annual Tribunal of Karnataka at Bangalore, B.R. Saraswati and others. ಯಾವ್ದು ಬೇರೆ ಬ್ಯಾಚ್ from ನಮ್ಗೆ ಸಂಬಂಧ ಇಲ್ಲ. And what I am submitting before my lord is the order dated 16/6/2016 may be kindly perused. That too in writ appeal 9862 of 2012. That was the writ petition. And the writ appeal,
Now, what are the facts of this?
yes, ma'am.
What do you, court officer?
Now, with respect to so far as my case is concerned, my lord, I am the owner of 1 acre of land which was acquired by the Jayaprakash Narayan 8th stage. Now, I have a challenge, I have the grounds where what I have sought for is there is a catena of judgments passed by this honorable court wherein the factual finding is recorded that JP Nagar 8th stage has been the proceedings has been lapsed. Any of the substantial implementation is not there with respect to the layout. This was the finding recorded in batch of writ petitions. Now, my lord may kindly appreciate, my writ petition was pending as on the date of pendency of the writ appeal may take my lord to the order dated 6/6/2016 in this matter. The batch of writ petitions were pending before the division bench, and therefore this honorable court was pleased to hold that this matter is to be listed in B group after disposal of writ appeal number 15015 of 2011.
6/6.
6/6/2016. Now, my lord may kindly appreciate the contention raised by me in this writ petition. My lord would find in my writ petition.
One second, let me go through this 14,015.
My lords, may I make one submission, my lords? The order dated, the order, writ appeal number 15015, that has been appealed in the Supreme Court, my lord. That is pending. That is the batch of SLPs that have filed before your lordships right now. Those are pending.
Once again, I'll have a look at this and come to you.
ಅಲ್ಲ ಅವ್ರು ಹೇಳೋದು ರಿವ್ಯೂ ಹಾಕಿದ್ದೀವಿ ಅಂತ. That means
It's not review, Radhanand, it's SLP only.
ಇಲ್ಲಿ ಮೇಲೆ ಅವರು when they refer, they say it's a review. Memo of review petition. ಇದು ಯಾವ್ದು 6/2/2023 ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. The writ appeal
1 second.
862 of 2021 disposed of on 6/2/2023. My batch of writ petitions. Page 64 of judgment may be kindly put. Writ appeal number 15015 in my list of authorities. Last judgment.
1515 appeal ಹಾಕಿದ್ದೀರಾ?
Please, SLPs, batch of SLPs are pending. On 15015.
What has happened in that?
Status quo order has been granted.
ಎಲ್ಲಿ ಅದನ್ನ ಅವ್ರು
Status
produce
quo order
ಮಾಡಿ-
has been granted.
ಎಲ್ಲಿದೆ ಅದು?
But they have only produced an order of one of the SLPs. I shall produce all of it.
ಅಲ್ಲ, status quo would be with respect to land which is subject matter of that.
No, see, it's like this. 15015 of 2011.
ನಾನು 15015 ನಾನಿಲ್ಲ, I am not a party there.
You need not be there in 150.
Only the dictum cannot be stayed, my lord.
See, listen. First, 3353 of 2016 was there. Writ of bill 3353 of 2016 was there.
Yes.
In 3353 of 2016, it has been held that the scheme has lapsed, JP Nagar 8 phase.
Yes.
Okay,
ಹೌದು
that is Sampangi and others.
ಹೌದು something is.
Now, that has been upheld by the Supreme Court.
Yes.
Okay,
ಹೌದು sir.
then you have other connected matters coming up.
Yes.
On the ground, on the strength of the judgment rendered in Sampangi, those
Writ appeals were
writ
disposed
appeals also have been allowed,
31st January 2023.
allowed or dismissed whatever in favor of the landowners.
Landowners.
Now, that they are saying is stayed before the Supreme Court and the status quo order has been passed.
ಅಲ್ಲ, the judgment is not stayed, the dictum is not stayed. And finding with respect to the scheme has been lapsed.
See,
That
his
is not-
scheme has been lapsed, acquisition need not lapse, that is also there.
No, in fact, in this matter, the.
Let us see,
arbitration
let us
side of
see,
the court
let-
was pleased
let
to
me call
record
it
a
off.
finding that acquisition aborts.
Let me call out in 2 weeks, let me see what happens. Find out and come, what has happened in Supreme Court with all the connected matters. They are also making their submission, no?
ಅಲ್ಲ, ಏನ್ ಹೇಳಿದ್ರೆ, there was ample time, they could have produced everything in the seriatim.
All right, they are doing it now, you also dig out and find out what has happened.
I can do that.
When do you want? After 2 weeks, on date kodi. At the request of parties, call on.
9.
Next week ಅಲ್ಲಿ ಹಾಕೋಬಹುದು, ಒಂದ್ ವಾರ ಸಾಕಾಗ್ತದೆ.
ಆಯ್ತೇನ್ರಿ, next week ಹಾಕ್ಬೋದೇನ್ರಿ?
My humble submission is it is pending before the Supreme Court.
ರಿಯಾದ್ ಏನ್ ತಗೊಂಡ್ ಬಂದ್ ಅವ್ರಿಗೂ ಒಂದ್ ಕಾಪಿ ಕೊಡಿಯಪ್ಪ, let there be consensus with
Please.
that.
Please.
See what has happened, one set of writ petitions you are lost before Supreme Court. JP Nagar 8th phase itself. See, Sampangi and others, it has attained finality.
Please.
Or ಅದ್ರ ಮೇಲೂ ರಿವ್ಯೂ ಹಾಕಿದಿರಾ?
ಏನು ಕ್ಲಾರಿಟಿ ಇಲ್ಲ, ಇಲ್ಲಿ ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಅಂತ ಹೇಳ್ತಾರೆ, ಮೆಮೋ ಆಫ್ ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಅಂತ ಹೇಳ್ತಾರೆ.
Lords, I shall verify and produce
ಅಪೀಲ್
it.
ಅಂತಾರೆ.
See, reading of whatever little papers you have placed over here reveals Sampangi and others have gone against you. It has attained finality. It has been held, the scheme has lapsed. And on facts, the acquisition also have been set aside with regard to the petitioners there.
Please.
Okay,
Please.
then after that, follow-up cases, it appears, there is no clarity over here.
ಅಲ್ಲ,
I shall verify and
It
produce.
appears that this court has gone with Sampangi and has struck down acquisition. Okay. But it appears that you have filed some SLP wherein you have got an interim order in your favor. ಏನಿದೆ correct ಆಗಿ place ಮಾಡಿ records, based on that we will go ahead.
Please, my lord.
And how they are applicable to this. See, 2 things I want you to clarify. Has the scheme lapsed, has attained finality or not? Okay,
my lord.
this is the first aspect. Scheme has lapsed, has it attained finality or not? This you find out and tell me.
In
Number one.
Sampangi's case,
Number 2. Are acquisitions set aside in those matters on the fact that possession has not been taken in the manner known to law? Or for what reason? Okay, see, this is because just because scheme lapses, it does not mean acquisition lapses.
No, the court has recorded a finding that the moment scheme has lapsed by operation of law, acquisition aborts. That is the finding recorded in Adjudication Notice.
That is under appeal, Allah, sir.
Then,
See, that is pending consideration before Supreme Court. Indoor Development Authority, offshore holdings don't hold it that way.
Literally, new Land Acquisition Act was the issue. Whether the acquisition has been lapsed under the new act.
Those two cases are against you.
Under section 27 of the PDA Act, it's a
36 won't
different
come
court
into-
by itself.
See, 36 will not be operative, that's all. But not necessarily acquisition.
No, there is a substantial, regarding
ಆಯ್ತು,
substantial
ನಿಮ್ದು
implementation, my
ನಿಮ್ದು
lord.
possession ಬಗ್ಗೆ ಏನ್ ಹೇಳ್ತೀರಾ?
Possession ಬಗ್ಗೆ, the cyclotype copy has been filled up and signed, which is in Sampangi's case, what has happened is similar to my case. And they admit that there no layout is formed.
16-2 ಆಗಿದೆಯಾ?
16-2 ಆಗಿದೆ.
16-2 ಆಗಿದೆ.
But ಏನಾಗಿದೆ ನಂದ್ರಲ್ಲಿ, there is a first notification passed. In the first notification, that was challenged. There was no scheme. The entire notification was quashed. The second and third notifications are issued. My land is not there in those notifications. But they proceed on the basis of the first notification which was issued without scheme and hold that acquisition prevails over. According to me, the moment the first notification is quashed on the ground that there is no scheme at all that was approved by the government, when the first final notification is gone, my land is not at all subject matter of the acquisition proceedings. Now they have issued 16-2 and reclaiming that no, that acquisition notification holds good. Therefore, I was constrained to knock the door of the Honorable Court after the khatas were restored in the name of the BDA. Therefore, I am constrained to seek for a relief that the scheme has been lapsed under section 27 of the BDA. These are the facts of this case. ಇಲ್ಲಿ second or third notification on land ಇಲ್ಲ. And first notification, when it is quashed, as there is no scheme at all approved, then that order is, when they do not challenge it, then they cannot claim that this land is within the acquired scheme. That is my submission. That's what I have made out in my case.
Okay, I'll call it next week then. Get all the details, what has happened in Supreme Court with regard to what case.
26, 27.
First week of September.
Why? First week of September.
Details ಎಲ್ಲ collect ಮಾಡಿ ಹಾಕ್ತೀನಿ. All other matters, there are a batch of matters brought which together there is a common order, but SLP has been filed over a different dates.
Allah, Sampangi's case has attained finality, my lord. My case falls squarely
Okay,
within.
anyway, you also find out, let him also find out.
Allah, Sampangi's case, there is no other review petitions filed.
I'll obtain information.
Allah, 2 ವಾರ ತಗೊಂಡಿದ್ರು, in fact,
See, first aspect is whether the scheme has been held to be lapsed or not. Okay, and has it attained finality? Then what about acquisition?
Scheme might fail, my lord, acquisition will not. Acquisition will continue. If, my lord, tomorrow the Honorable Supreme Court were to hold that the order passed by division bench is incorrect and were to uphold the scheme, my lords, then the ground on which they are urging, my lord.
No, what he is saying is one set of writ petitions have already attained finality. That's Sampangi's case. And the writ appeals also have been decided on the basis of Sampangi's case only.
Sampangi's case on facts, my lord. But the finding in the division bench, my lord, is a much larger finding than what was found in Sampangi's case. Sampangi's case on facts for the survey number.
Okay.
So therefore, my lords, for them to say, my lords, that Sampangi's case has attained finality will not help them. Different survey number.
No, Sampangi's case I have produced, there is a finding recorded. Only 396 acres were taken possession out of 2,006 and only 2,600 sites were farmed out of total extent of 1,056 acres. That is the finding recorded in Sampangi's case. Therefore, the Honorable Court was pleased to hold that under section 27 of the BD Act, there is no substantial implementation which has resulted in lapsing of the scheme.
I'll make my submissions.
Take a shorter date. Next week, ತಗೊಳ್ಳಿ.
27, 28 ಯಾವ ತರ ತಗೊಳ್ಳಿ?
28.
They have not seek further time.
Vachan will not unnecessarily seek time, don't worry. The request of parties call on 28th.
My lord, Siddharth Suman name may kindly be deleted, my lord.
Job is to delete the name of Sri Siddharth Suman as the advocate appearing for the petition.
Hello.
Number 6.
This point. This case, my lord, we have filed received by the report, my lord, in dated 8/12/2023, my lord.
ಇನ್ನೊಂದು ರಿಪೋರ್ಟ್ ಹಾಕಕ್ಕೆ
ಇಲ್ಲ ಇಲ್ಲ ಅದೇ ರಿಪೋರ್ಟ್ 8/12/2023 ಹಾಕಿದ್ವಿ ಫೈಲ್ ಆಗಿದೆ. Say that, my lord, some land is encroached by the, my lord, BDA to regarding HBRBR layout is concerned, my lord. On that regard, my lord, specific direction go to the AG to conduct the survey and submit the report. I have submit the reports with sketch, my lord.
27/9/23 ಆರ್ಡರ್.
ಅದೇ ಅದ್ರ ಮೇಲೆ
ಯಾವ ಹಾಕಿರೋದು?
27/9, my lord, filed it 8/12/2023.
ಇಟ್ಟಿದಾರಾ? I'll collect it and go through it.
ಸರ್ವ್ ಮಾಡಿದೀವಿ 5/12/2023. 8/12/2023, my lord.
Government. 8/12. ನೋಡಿ ಇದೆಯಾ? ಬಿಡಿ ನಾನು ತರಿಸ್ತೀನಿ.
We received the copy today or last. Today we received the copy. That's in the report.
Page 6 and 7, my lord. 7 ನಲ್ಲಿ ಹೇಳಿದ್ದು. Purely nature of a civil dispute, my lord, regarding the road is concerned, my lord, they say that
ಹಾಕಿಲ್ವಾ?
Hmm.
Lordship, the only question is, there is the encroachment, but it is not the BDA encroached, your Lordship. The allottees have encroached and built the building, your Lordship,
Not the BDA.
not BDA. Because we have submitted our report on 17/3/2023, your Lordship. ಅದು ಯಾವ ಸೈಟ್ ನಂಬರ್ ಬಿಲ್ಡಿಂಗ್ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀವಿ. 17/3/2023, Lordship. Submitted a map. 1.48 quintals ಅಂತ ನಾನು ಏನು ತೋರಿಸ್ತಾ ಇದ್ದೀನಿ, Lordship. That is the encroachment by the site owners and constructed the
ಮತ್ತೆ
building.
BDA ಅವರು ಒತ್ತುವರಿ ಮಾಡಿದಾರೆ ಅಂತ ಇವ್ರು ಹಾಕ್ಬಿಟ್ಟಿದಾರ.
In respect of my lord, at the present status is my lord, ಓಣಿ ಅಂತ ಇದೆ, ಆ ಓಣಿ ರೋಡ್ ಅನ್ನ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದೆ ಅಂತ ನಾವು ಹೇಳ್ತಾ ಇರೋದು. ಇಸ್ ನಾಟ್ ರಿಗಾರ್ಡಿಂಗ್ ಪ್ರಾಪರ್ಟೀಸ್ ಕನ್ಸರ್ನ್, ಅದು ಓಣಿನೇ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇರೋದು.
The Tahsildar says it is a road.
ಅಲ್ಲ, that is the road, your
It's
Lordship.
a road. How can the black BDA village over here? There is a protect, he has to protect the roads. The Tahsildar says it's a road.
What is your case about?
Yes.
I will also go through that report and make a submission and petition.
No need of it.
Mandamus, my lord, the sought for the mandamus, my lord, regarding, my lord, there is an encroachment made by the layout BDA and two
There is one more
592.
5923 ಒಂದು order ಮಾಡಿದ್ದಾರೆ ಮತ್ತೆ ಯಾವ
kindly say prayer, my lord, issued or prohibition order directing similar nature, prohibiting the respond number 2 or any one claiming under from the forming sites or any other activity.
Filing a suit, no.
Please, my lord.
Filing a suit.
Suit for easement, my lord.
I'll issue a direction to the authorities to take necessary action.
Actions. Yes.
Yes.
Huh?
On their
Remove any encroachment.
one submission my lord. First petition ತಿರೋಗಿದಾರಂತ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬಿಡ್ತೀನಿ ಫಾರ್ಮಲ್ ಆಗಿ. Petition number 1 died.
ಎಲ್ಲಾರು
ತಂದ್ಬಿಡ್ತು ರೆಕಾರ್ಡ್ ಮೇಲೆ.
ಎಲ್ಲಾರು application filed.
ಅಲ್ಲ ಸೆಕೆಂಡ್ ಸಾವಿರ ಫಸ್ಟ್ ತಿರೋಗಿದಾರಂತ ಈಗ.
It's public in, there is no
ಅಲ್ಲ,
private interest
I
affected.
will file an SR
It
application.
stands abated as against petitioner number 1 is concerned.
Petition number 1 ಈಗ recent ಅಸುತ್ತೆ.
ಆಯ್ತು, as long as petitioner number 1 is concerned, it stands abated.
Purely PIL nature, my lord.
ಅಷ್ಟೇ, ಬನ್ನಿ.
I will file it can't day after tomorrow order.
ಏನ್ ಬೇಕಾಗಿಲ್ಲ, not necessary. They are not getting any rights over the property. They are not getting any
That
rights.
doesn't mean that BDA or authorities can encroach the government property and obstruct them, because BDA may not is the custodian of the land. Tahsildar says we lodge a police complaint, they submitted a report, should not take action and the alert is at least, why can they take, my lord?
Yes, they will initiate action in accordance with law.
I included even that person also, my lord. After that,
Who has encroached?
Lord, account as BDA has encroached, my lord. The report also,
Fine,
Tahsildar
we'll-
also says BDA has
We will
encroached.
order that, we will order that. That's the finding also, that BDA has encroached.
Then what is their answer, my lord? They have not said anything about that.
No, your Lordship. My sketch, your Lordship, 17/3/2023 may be looked into, your Lordship.
See, council, have you encroached or not?
No, I have not encroached.
Then who has encroached?
The allottee have encroached on the road. They have constructed.
Well,
That is what I
then,
am
my lord,
saying.
let them file an affidavit to that effect and
I have already.
produce the allotment letters
I have
and
already put
everything,
the
my lord.
affidavit and sketch, your Lordship, 17/3/2023.
Allottees have not been made a party over here.
ಈಗ ಮಾಡಿದ್ದೀವಿ. ಇಂಪ್ಲೀಡಿಂಗ್ ಹಾಕಿದ್ದೀವಿ, ಹಾಕಿದೆ.
ಇಲ್ಲಿ allottees are not party, your Lord.
ಸರ್ ಇಂಪ್ಲೀಡ್ ಆಗಿದೆ ನೋಡಿ ಸರ್.
ಯಾರಾಗಿದ್ದಾರೆ ಸರ್? ಎಲ್ಲಾಗಿದ್ದಾರೆ?
ಮೆಹಬಾಸ್ ಆಲಿ ಅಂತ 5 ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಾಡಿದ್ದೀವಿ. ಇಂಪ್ಲೀಡಿಂಗ್ ಐಎ ವಾಸ್ ಅಲೌಡ್.
Served ಆಗಿದೆ, been served.
ಐಎ ವಾಸ್ ಮೇಡ್.
Who has encroached?
The allottees, your Lordship. I have given the site number also.
Where is your affidavit?
Lordship, 17/3/2023, your Lordship.
ಆಯ್ತು, ಬನ್ನಿ ಬರ್ಕೊಳ್ಳಿ. The case of the
ಅವ್ರ ಅಫಿಡವಿಟ್ ಓದ್ಲಿ ಸ್ವಾಮಿ ಎಲ್ಲಿ ಹೇಳಿದಾರೆ ಅಂತ ಅವರು ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ ಅವರು.
Lordship, para 3, your Lordship, I submit that after the completion of the spot inspection and survey, I prepared a report and sketch of the property in question. The copy of the report and sketch is herein produced as annexure R3 and R4, your Lordship. In the R4 sketch, your Lordship.
Then why not
R
searching to
dark blue,
specify?
your Lordship. 0.148, 1.48, your Lordship. ಈ ಬಣ್ಣದಿಂದ ಗುರುತಿಸಿರುವ ಪ್ರದೇಶವು ಸರ್ವೆ ನಂಬರ್ 37 ಮತ್ತು 54ರ ಮಧ್ಯದಲ್ಲಿರುವ ಬಂಡಿದಾರಿಯಲ್ಲಿ ಪ್ರಾಧಿಕಾರದಿಂದ ಹಂಚಿಕೆಯಾಗಿರುವ ನಿವೇಶನಗಳ ಸಂಖ್ಯೆ 612, 614, 616, 618, 620, 622, 624/1, 624/2, 624/3, ರವರು ಒಟ್ಟು 1.5 ಗುಂಟೆ ಪ್ರದೇಶವನ್ನು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡು ಕಟ್ಟಡ ನಿರ್ಮಿಸಿಕೊಂಡಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. The allottees have encroached and built the construction, and I have no objection to remove the encroachment, your Lord.
Then you remove, sir. Then you remove, sir.
In
You are
respect
all
of my lord, own is concerned, my lord, the revenue authorities are responsible. In respect to other case is concerned, my lord, we are not responsible because, my lord, own is to belong to the state. On that regard, my lord, I have filed the report.
The case of the petitioners is that they are owners of certain lands in survey number 54/1 of B. Sennasandra, Kerpuram Hombli, Bangalore East Taluk. And that English.
ಅಯ್ಯೇ ಹಾಕ್ಬಿಡ್ತೀನಿ ಇಂಪ್ಲೇಡಿಂಗ್ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬಿಡ್ತೀನಿ ಫಾರ್ಮಲ್ ಆಗಿ. ನಾವು ಆರ್ಡರ್ ಮಾಡಬೇಕು.
Abates has
ಅಲ್ಲ ಇನ್ನೂ ಆಗಿಲ್ಲ, ಅದು ಟೈಮ್ ಆಗಿಲ್ಲ,
a.
1 month ಆಗಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಲೆಟ್ ದಿ ಫಾರ್ಮಾಲಿಟೀಸ್ ಕಂಪ್ಲೀಟ್.
The request of petitioner, call on next week date for it.
27. Date 27. The number 7, Sridhar ji. The number 7.
Survey report had to be filed. So far, took place. in
Confirm my
January.
lordship, Commissioner of Survey, it's 1 week time may be given.
The request of which a call on.
A date may be fixed.
28. 28.
Right, 28.
28. The number 8, Nagesh is.
And for R1, my lord.
One submission, my lord. Serial number 6 is concerned, kindly record, my lord, that the report is filed by the state.
It's all right, irutte.
Please.
Appearing for R3 million. In this case, my lord, even though the land is not required for formation of or widening of road, they issued a notification to acquire my land. My lord, in the year 2008 itself, 26.5 guntas have been notified. Out of that, they used only 16 guntas. The remaining 9 to 10 guntas are still remains for widening the road. My land is not at all required. Adjacent lands have not been notified by the land acquisition officer. Only my land has been notified, my lord. And they filed objection stating that we are not going to give a for petrol bunk. Now they have given the remaining 9 to 10 guntas for erecting the petrol bunk, my lord. I have produced photographs also. ಅವ್ರು ಕೊಟ್ಟಿಲ್ಲ, ನಾವು ಪೆಟ್ರೋಲ್ ಬಂಕ್ಗೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. I have filed a detailed statement of objection along with photographs, my lord.
Your lordship, the contention of the petitioner is that the authorities intend to create a third party interest over the notified land. However, your lordship, as your lordship is aware, once the land has been acquired under the NH Act, the ownership of the land rests with the central government. However, for the purpose of your lordship had directed me to file an affidavit stating the purpose of the acquisition of land, and that has been filed duly by the respondent number 3. If your lordship can. Prior to that, my lord, I would just like to take your lordship's kind attention to the notification, the 3D notification. It's a annexure R2, my lord, page number 21. No, it's not only the land of the petitioner that has been notified under 3A and 3D. However, there are multiple other lands pertaining to multiple other owners. The geographical location is a different little bit in terms of the village, but in terms of the stretch of the development of the highway, it is one and the same, my lord. Subsequently, it is the malefites that has been being interpreted or contended by the learned petitioner here. In respect of that, I had argued before your lordship, by virtue of the judgment by the Honorable Apex Court, they have not produced any document, nor they have relied upon any substantial evidence produced before your lordship to contend any malefites on or the intention on behalf of the respondent, my lord. Page number 21 of the statement of objections. 21 and 22. Annexure R2, my lord. So this is the situation at hand, my lord. Subsequently, as your lordship had directed me to file the affidavit stating the purpose of the acquisition of land, my lord, the same has been filed and it has been clearly determined, my lord. The same has been acquired for the purpose of wayside amenities and creating the laybys that is necessary on the highway, my lord. So that is what it has been brought on record by way of an affidavit. So this is the situation at hand, my lord.
Show it.
Please, my lord. Affidavit, my lord. Affidavit, page number 4, my lord. The same was filed on 3/7/2024. Lordship, page number 4. If I may read, my lord. It is submitted that under section 3A1 of the NH Act, if the central government is satisfied that for the public purpose, if any land is required for construction and development of national highway, may issue a notification declaring its intent to acquire the land. The section 3(1) of the NH Act is extracted here under further ready reference. 3A, power to acquire land, etc. Where the central government is satisfied that for the public purpose, any land is required for building, maintenance, management, or operation of a national highway or part thereof, it may by notification in the official gazette declare its intention to acquire such land. It is submitted that the subject land in this instant petition was acquired for the public purpose of building, maintenance, and operations of the national highway, specifically for the purpose of wayside amenities, including but not exhaustive to lay-by for carriages and washrooms in the project stretch. It is submitted the Ministry of Road Transport and Highways (MoRTH) has issued policy guidelines dated so and so for development of wayside amenities along national highway. And as per clause 3, subclause 1 of the national highway, efforts would be made by the highway authorities to set up wayside amenities at every 40 to 60 km of travel distance. For divided carriageway, this norm shall be applied separately in each direction. In pursuance of the said guidelines and within an intention to comply with the same, the subject land of the petitioner came to be notified and acquired by duly complying the acquisition procedure laid down in the NH Act and for the purpose of development of the national highway, specifically for the purpose of development of wayside amenities. Your Lordship, the petitioner has not challenged the authenticity of the acquisition proceedings. There is no dispute in respect of that. It is only the usage of the land and subsequently the malefites that has been being contended by the petitioner. The same, there was no objections filed with the SLAO when the SLAO was conducting the objections to be taken heard under 3C, my lord, as per the provisions of 3C.
What is that you intend to use this land for? Where have you said that?
My lord, in the affidavit, my lord, it is for the purpose of wayside amenities. Now, in respect of the specifications of the constructions and everything that happens subsequent to acquisition, my lord, once we take the possession, it is given to the concessionaire for the development and preparation of the structure and planning and everything by virtue in accordance with the guidelines and the provisions of the National Highways Act and the guidelines they laid down thereunder. Accordingly, subsequently, it is approved and then the construction happens, my lord, because the construction in respect of wayside amenities is done by a concessionaire and a third party. That is accepted. So it is for the purpose of public purpose, my lord. And also by virtue of the doctrine of eminent domain here, the petitioner is entitled for a compensation, which we have already determined and the award has been determined, my lord, in respect of the land. And the same has been deposited with the reference court as well because the...
Have a policy for partnering with the landowners for whatever developmental activities you want to do by wayside amenities.
Please, my lord, there is a provision under... Please.
Petrol bunks are under your control. If you are giving it for a fuel station, why can't permission be granted to him only to run a petrol bunk?
No, my lord.
Rather than awarding it to somebody.
My resp-
Someone who is not in the local area, someone who has to come from some other place.
my lord,
Why this attitude?
my respectful submission in that regard, my lord. There is nothing which has been determined that the particular land is being used for the fuel station only. There is no deciding factor upon that, or it has been decided for the purpose of fuel station. It is being acquired for the purpose of wayside amenities. The fuel station might fall under the umbrella of wayside amenities, though. However, it is used for the purpose of wayside amenities, my lord. Additionally, the petitioner has not produced any document here
We
to
have
determine
produced
whether
photographs which demonstrate, my lord. Initially, they filed objection.
Council, we have to go by the law. It's just a suggestion made to the other side.
No, my lord, my respectful submission is, initially, at the time of filing a statement of objection, they stated that for widening the road, they issued notification. And in their objection, they clearly stated that we are not going to give the notified area for any petrol bunk. Now they are given the said land for petrol bunk. I have produced photograph.
Where is the notification which says so? Where is the notification which says so?
My lord, there is no any such notification, but I have produced photographs. May kindly peruse for a kind moment photographs. Ekantandre, idರಲ್ಲಿ 26 and half.
Have to show some illegality, council. Where is the illegality? Show me.
My lords, illegality idರಲ್ಲಿ ಏನ್ 26 ಗುಂಟೆ ಅಕ್ವೈರ್ ಮಾಡಿದ್ರು 2008 ಅಲ್ಲಿ ಅವ್ರು ಯುಟಿಲೈಸ್ ಮಾಡ್ಕೊಂಡಿರ್ತಕ್ಕಂಥದ್ದು ಓನ್ಲಿ ಅರೌಂಡ್ 16 ಗುಂಟಾ ಸ್ವಾಮಿ. ಇನ್ನ 10 ಗುಂಟಾಸ್ ಹಾಗೆ ಇದೆ, ಅದನ್ನ ಅವ್ರು ಯುಟಿಲೈಸ್ ಮಾಡ್ಕೋಬಹುದು. ಆಮೇಲೆ ನನ್ನ ಅಕ್ಕಪಕ್ಕದ ಜಮೀನುಗಳನ್ನ ಯಾವ್ದು ನೋಟಿಫೈ ಮಾಡಿಲ್ಲ. ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ, ದೇ ಸ್ಟೇಟೆಡ್ ದಟ್ ಬೇರೆ ಬೇರೆಯವ್ರ ಲ್ಯಾಂಡ್ ಅಕ್ವೈರ್ ಮಾಡಿದೀವಿ ಅಂತ. ಆ ಕೋರ್ಮಂಗ್ಲಾ ವಿಲೇಜ್ ಅಲ್ಲಿ ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಬಿಟ್ರೆ ಬೇರೆ ಯಾವ ಪ್ರಾಪರ್ಟಿನೂ ಇವರು ನೋಟಿಫೈ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಅಕ್ವಿಸೇಷನ್ಗೆ. ಅಂಡ್ ದೇರ್ ಇಸ್ ಎ ಆಯಿಲ್ ಇಂಡಸ್ಟ್ರಿ, ಸನ್ಪ್ಯೂರ್ ಆಯಿಲ್ ಇಂಡಸ್ಟ್ರಿ ಇದೆ ನಮ್ಮ ಜಮೀನ್ ಪಕ್ಕ. ಅದ್ರ ಬಗ್ಗೆ ಇವ್ರೇನು ಮಾಡ್ತಾ ಇಲ್ಲ. ಅದ್ರದ್ದು ಯಾವ್ದು ಆ ಪೋರ್ಷನ್ ಅನ್ನ ಯಾವ್ದು ಇವರು ನೋಟಿಫೈ ಮಾಡಿಲ್ಲ ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಳಕ್ಕೆ. ಆ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಅಲ್ಲಿ ತಾವು ಪರಿಶೀಲನೆ ಮಾಡ್ಬೋದು.
Rather, if I can bring it to your lordship's attention, the earlier 26 guntas of land which was acquired, 17 guntas was, as on that day in 2008, was used for the widening of the national highway. Then the other portion of the land is being used for now the future purpose. However, my lord, once the land was acquired for the entirety of for the total of 26 guntas, yet the petitioner continued to grow crops on those remaining 10 guntas. And the same, rather, the petitioner has encroached and taken the illegality over that land which vested with the central government back in 2008 itself, my lord. And that has been admitted by the petitioner in the writ petition government.
My lords, ಇದರಲ್ಲಿ ಟೋಲ್ ಇಂದ ನೆಲಮಂಗಲ ಟೋಲ್ ಇಂದ ಅರೌಂಡ್ 10 to 12 kilometers ನನ್ನ ಲ್ಯಾಂಡ್ ಇರುವಂತ. ಅವರೇ ಹೇಳ್ತಾರೆ ಅಬೌಟ್ 40 to 60 kilometersಗೆ ಒನ್ಸ್ ಇದು ವೇಸೈಡ್ ಅಮ್ಯುನಿಟಿ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. ಈಗ ನೆಲಮಂಗಲದಿಂದ ನನ್ನ ಜಾಗ ಇರತಕ್ಕಂಥದ್ದು 10 ರಿಂದ 12 ಕಿಲೋಮೀಟರ್. ಅವ್ರಿಗೆ ಬೇರೆ 40 to 60 kilometers ಅಂತ ಅಂದಾಗ,
with regard to policy matter,
my lord, the guidelines ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. The guidelines very clearly demonstrate that minimum 1 hectare ಅವರು ಅಕ್ವೈರ್ ಮಾಡ್ಕೋಬೇಕು ಸ್ವಾಮಿ, ನೋಟಿಫೈ ಮಾಡ್ಬೇಕು.
If I may answer in that regard, my lord, if your lordship may come to page 4, my lord, 3.3, my lord. Please. Not the 40 to 60 kilometer, what the petitioner is determining upon, it is that it is effort shall be made for every distance between 40 to 60 kilometers. There shall be a wayside amenities or a kiosk or a tea and washrooms and other laybys. if your lordship may see page 4, my lord, clause 3.3, the wayside amenities should not be in the vicinity of toll plaza. The minimum distance from the toll plaza shall be at least 1 kilometer. Here, the petitioner himself is being admitting that there is 10 to 12 kilometers of a distance between the toll plaza and the land acquired here under. Subsequently, my lord, the 1 hectare which has been contended by the petitioner, if I may take your lordship's attention to clause 5, my lord, subclause 5.1, land already, where the land for developing small outlets, my lords, 5.3, my lord, where it says the size of land shall be minimum 200 square meters. Only 200 square meters. At least the minimum requirement is so. Subsequently, subclause 2, such outlet would provide toilet facilities separately for every kiosk for tea, snacks, and package items, and it is along wayside amenities on private. So this is what the clause is. The minimum land requirement is 200 square meter, my lord, but not rather 1 hectare as being contended by the petitioner.
There is a 11 guntas land available to them, my lord. 2008 ಅಲ್ಲಿ ಏನ್ ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿದ್ರು ಅದರಲ್ಲಿ ಅವ್ರಿಗೆ ಇನ್ನು ಅರೌಂಡ್ 10 to 11 ಗುಂಟಾಸ್ ಅವೈಲಬಲ್ ಇದೆ. ನನ್ನ ಲ್ಯಾಂಡ್ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಇಲ್ಲ ಸರ್.
You do one thing, you show how the land, the acquiring your land for creation of wayside facility is against the policy of NHAI, then in that event I can grant you.
A date may be given.
My lord,
Please we can't.
my lord, there is urgency in this matter, my lord, and being petitioned as being there is subsequent dates being taken, my lord. So my humble request is if it may be taken up this week only sometime or next week anytime, my lord.
28.
28, my lord, 27th or 20. Please, my lord, humble. 27.
Interim order may be extended.
At the request of parties, call on 27. Parties are directed to 27. Interim order.
ನೀವು objection ಹಾಕಿದ್ದೀರಾ?
Notice ಆಗಿದೆ. Component number 2.
ಯಾರು R2?
Special Land Acquisition Officer. National Highway Authority. ಅವರೇ appear ಆಗ್ತಾರೆ. ಹನುಮಂತ್ ರೆಡ್ಡಿ. R2. 3. ಅವರೇ accept ಮಾಡಿ.
Yes, case.
9. Sri Rajshekar. Remember 9.
For the
Objection
petition,
is ready, my lordship. 1 week time.
1 week to do the.
take a step regarding R3, my lords, amended petition is filed.
To do it, 1 week to do the next.
10. Rakshita DJ.
My lords, date may be fixed on.
First ಮಾಡ್ಬಿಟ್ಟು.
Please.
One office objection, that is legible copy of annexure B, my lord.
Produce it.
Not, we have produced and we are not questioning the acquisition, my lord. You are only seeking for modification of the award. If your lordship kindly comes to page 36, in disregard, we have, council submission is also made, my lord, that copy is legible.
Office objection. Yes, will you consider?
My lord, the award itself gives an option for the landowners either to choose cash or the developed site, my lord. Since it has been passed into 2021, my lord, 24 is the representation. In the meantime, since they have not opted the amount, our award amount may have been deposited before the trial court.
Can you redo it?
Please.
You can redo it, na?
I'll seek instead. Next week.
ಅವಾಗ ಇತ್ತೇನಪ್ಪ ಪಾಲಿಸಿ 21
Yes, it was one.
ಇತ್ತಲ್ವಾ ಸರಿ ವಿಲ್ ಆರ್ಡರ್ one. The case of the petitioner is that
That observation, if the amount.
petitioner is that his 1 acre 5 guntas of land situated in survey number 50/2 of Pailakere village, Hesarghatta Hobli, Yelahanka, Bangalore North Taluk, has been acquired by BDA And in spite of his request, they have not granted him alternative land,
The developed site.
developed alternative land, the policy of BDA. And instead, they have deposited monetary compensation before the reference court. Full stop. Hence, the present writ petition is filed with a prayer to direct the BDA to consider his representation and grant developed alternative land as per the policy of BDA/state instead of monetary compensation. Full stop. Next para. The learned counsel for the BDA upon instruction submits that the land of the petitioner was acquired. Notification date and
But the preliminary notification is
final
final, my lord, to 31/10/2018. Dr. Shivram
by
Karnataka,
way of final notification dated
31/10/2018.
31/10/2018. And the award has been made, Yavaga,
15/9/2021.
15/9/2021. And there was no request by the petitioner at that particular point of time for grant of land as land in lieu of monetary compensation, because of which compensation has been deposited before the reference court. Full stop. It is further submitted that petitioner has not produced all the necessary document to show that he is the sole absolute owner of the property which is acquired. Full stop. However, the advocate for the petitioner submits that, however, the advocate for respondents 2 to 4 submits that if the petitioner were to make a proper request along with the necessary documents, the request of the petitioner will be considered. Full stop. Next, for admittedly, policy of the state/BDA, permits the petitioner to avail compensation for the land acquired, either
By way of cash.
by way of monetary compensation or developed sites. And it is for the petitioner to opt either for one of them. Petitioner to opt for either of them. Full stop. In the instant case, there has been some delay by the petitioner in exercising his option. Full stop. However, it should not come in the way of petitioner opting for either of the options, either of the mode of compensation, by producing necessary records. Full stop. Hence the following order. Next, petitioner is given liberty to make necessary representation to respondent number 2 and 3 BDA, 2 and 3, respondent number 2, 3 and 4, respondent number 3 and 4, along with all the necessary particulars to show that he is the sole absolute owner of the property which has been acquired. Full stop. The same shall be made within a period of 3 weeks from today. Full stop. Next, upon receipt of the said representation, the respondent number 2, 3 and 4 shall consider the request of the petitioner, and if the petitioner is able to provide all the necessary particulars to show that he is the sole and absolute owner of the property concerned. And there are no rival claimants. Respondent number 3 is given the liberty, 2 and 3 are, 3 and 4 are given the liberty to withdraw the general award and grant developed land as compensation for the land acquired in terms of its policy, Writ petition disposed of without.
Okay. But within period of this,
The said exercise shall be done within a period of 3 months after
If the amount.
3 months apart, time for after the receipt of representation from the petitioner.
11.
And opportunity to authority to withdraw the amount if already default.
You can always withdraw.
Say number 11, and for the petitioner,
Hmm.
office number 3.
Ananda K.
The office number 3, I produced the relevant portion of the final notification, my lord, and I gave an explanation also. But the office objection is that, my lord, I required to file.
Survey number ಸರಿಯಾಗಿ ಮಾಡಿಲ್ಲ ಅಂತ
ಇಲ್ಲ, no, that's also I gave an explanation. As on the date of initial acquisition, my survey number is survey number 159/5. Subsequent year, it is renumbered as survey number 150/9/10 and 11. Both are stated in my relief column also.
Observations kept open.
PRR 1, my lord.
PRR 1.
AGR1, R2, Vachan.
B. Vachan.
ನೋಟಿಸ್ ತಗೊಳ್ಳೋದು ಫೈಲ್ ನೀವೇನು ಹುಡುಕ್ಬೇಕಾಗಿಲ್ಲ.
PRR.
11. Freshmats.
Please, my lord, please.
B. Vachan.
For R2. ಯಾವತ್ತಿದೆ?
28 and
PRR1 ಯಾವತ್ತಿದೆ ರೀ?
28.
28
20. 27, 28. ಎರಡಿದೆ ಸ್ವಾಮಿ. 28.
28.
PR 2/30. PR 30. 30th.
ಯಾರು ಹೇಳ್ತೀರ ಅವ್ದು ಹಾಕ್ತೀನಿ ಅಷ್ಟ.
30. 30th.
30th, sir.
Column 30th.
Sir, the
1.
12. Nagesh, yes.
Comply the office objections, my lord, within 2 days. A
Yes,
date may
what
be
we-
fixed.
Time
27th.
is granted to.
Lord, in this case, my lord, petition, my lord, without challenging the notification, they say that, my lord, obstruct from the respondent KDB not to obstruct the lands, my lord. Here, my lord, in the year of 2006 itself, my lord, notify the land.
ಅದನ್ನ ಪ್ರೇಯರ್ ನಾವು ಇವಾಗ ಚೇಂಜ್ ಮಾಡ್ಕೋಬೇಕು ಸರ್. ಅದಕ್ಕೆ
Without
we are going
challenging
to
that, my
comply
lord.
the office objections within 2 days.
ಆಯ್ತು, 1 week to do the needful. ಏನ್ ಬೇಕೋ ಮಾಡಿ.
Date may be fixed. 27th.
ಫಸ್ಟ್ ಮಾಡ್ರಿ, ಮಾಡ್ಬಿಟ್ಟು ಮೂವ್ ಮಾಡ್ರಿ.
13. Ananda K.
days time may be. 2 days time may be.
ಆಯ್ತು, 1 week to do the needful.
14. Harish Bhandari.
Same amount.
15. Rammurthy B.
For the case.
Okay.
Number 15. Murgesh V. Charati.
I'm appeal person.
Prasann Kumar. Mohammed Tippu Sultan.
Ready?
Rajendra Kumar Singh.
Is not there.
Is not.
Registry to delete the name of TP Rajendra Kumar Sungya as the advocate appearing for RP. Yes, ready na?
Yes, now ready.
Huh?
We are ready.
You ready alla?
Ready.
Kudi.
But that is, the petitioner has challenged the acquisition proceedings only in respect of the social property, only in respect of the scheduled property. That I have taken a concession that a survey number 40/5B was not acquired, was not notified in the said alleged notification. In spite of that, the respond number 2 demolished the building and also
Audit sheet put it. Last time why it was adjourned?
last time that I have produced the documents.
Amendment application. Amendment carry out ಮಾಡಿದಿರಾ?
Carried. Amendment is carried out and filed amendment. Also that is. And also I have produced the documents. The Lordship directed me to produce the body and RTC extracts I have produced, my lord. Along with that. The documents.
The documents and I don't know. 40 RDC expect.
ಬೆಳಗ್ಗೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಂತ ಹೇಳಿ ಮಾಡಿ.
Preliminary notification date ಏನು?
Preliminary notification 1977 my lord. Notification.
Final notification?
Final notification 85 my lord. On submission. Final notification in 1985. My lord, at page number.
Has been acquired, survey number 40/5 has been acquired,
Yes. My lord, as on the date.
ಏನ್ acquire ಆಗಿದೆ ಹೇಳ್ರಿ?
Place my lord.
40.
Survey number 40/5 is acquired.
Is acquired. ಎಷ್ಟು ವಿಸ್ತೀರ್ಣ ಎಷ್ಟು?
Not the 2 acres 38. 2 acres 30 guntas. 38.
2 acres?
38 guntas.
38 guntas have been acquired.
Yes.
Okay.
Yes.
When did, okay, ಅಲ್ಲಿ 40/5
Not 2 acres 39 guntas is what is put. Out of which 1 gunta is a kharab and 2 acres 38.
ಅದರಲ್ಲಿ 40/5B ಅಂತ ತೋರಿಸಿಲ್ಲ.
ಇಲ್ಲ ತೋರಿಸಿಲ್ಲ.
When did 40/5B come into existence?
Well, there is I have produced the sale deed. 1964.
Sale deed doesn't come into picture.
Well, there is I have produced the document, page number 17. The Podi. 21/1/1969. Page number 17, my lord. Documents.
New produce ಮಾಡಬೇಕಿತ್ತು. You had undertaken.
But he himself had stated, because it was there a state document, not according to us. In the award, we have mentioned that the property has been coded subsequently. Award proceedings are produced before this court to show that as per the award,
I have asked the documents, government.
My lord's been placed on record.
When they were ported, Ashta. See, if it is ported before acquisition notification, he has a case.
Please.
If it is ported subsequent to acquisition notification, his case will be dismissed. Ashta.
Please. Lord's, Lord's, body has been effected according to the document produced by him, my lords, in 1969. But the crux of the issue, my lords, is, my lords, the acquisition notification acquires the entire extent, 40/5, which includes his predecessor in title also.
See, when 40/5 was not in existence, how can you acquire it?
40/5 includes A and B, my lords. Even though it's been ported subsequently, that
So when was 40/5 was ported? Tell me that.
my lords, the document that revenue records show that it's in 1969, no doubt. But the same was not, my lord, that same was not carried out. It was not shown in the Panis. So the assessment records clearly shows that it was still 40/5. So notice has been issued, acquisition notice has been issued, his predecessors in titles have been heard. Compensation has been deposited, it has been withdrawn.
Who has withdrawn it?
His predecessor entitled, that
It is
material is available, my lord.
deposit, everything is there
That
on record. No, may I make the submission? As per section 17 of the BDA Act, Lord, I am supposed to look into only the assessment register of the property. If, as per the assessment register, my lord, if it is shown that survey number 40/5 was in existence, I have notified survey number 40/5. Lord, it is for them. It is for the landowners who claim that, my lord, their land was coded or, my lord, it was bifurcated into two numbers. My lord, it was their duty to, my lord, get it rectified at that point of a time. And admittedly, I have not exceeded a land which I have notified. It is the land which I had notified, and my lord, the extent is the same. 5A and 5B together constitute 2 acres, 39 guntas. Lord, that is what has been notified. And Lord, in the award proceedings also, it is not that, Lord, I have not taken note of it. When the objections were filed by the landowners that the land has been coded, I have taken note of it. And I have passed an award to an extent, including both these properties, survey number 40/5 and 40/5B.
When did you purchase the property?
Subsequent to the
That is,
notification.
Now, when did you purchase the property?
My vendor was purchased in the year 1964, my lord.
Ah,
The PODs was 21/1/1969.
ah,
Mutation was effected in the year 1968. That's on page number 18. And that is 30/12/1968, it was effected. And that the name was entered in the record of rights. Prior to the acquisition, that's 1977-78, I have produced the copy.
so when did you purchase, sir?
I have purchased in the year 2002.
How do you get a right then?
But there's my vendor, I have purchased, my vendor has purchased the property in the 2000. Subsequently, I have purchased the property. But there's
Sir, after 1964, the person purchases the property.
That is survey number 40/5B.
40/5B.
5B.
Okay, 40/5B.
And subsequently, he sold to my vendor,
When did he sell?
2000.
Now, why did this become 5A and 5B?
But there's that it was subdivision.
By
It was
whom?
coded,
By whom?
by the revenue authorities. That code was affected,
In the year 1969.
68.
69.
I have produced the.
69.
Code is in the year 69 apart.
69, madam. Code was, I have.
Mutation is in the year 68 in the name of the owner.
Mutation was affected 30/12/1968. And subsequently it was coded. And that name was entered in the record of rights. I have produced the record of rights, that is where there is some of the records.
Whose name was there?
That my vendor's name was there.
What's his name?
Elizabeth, Philip Elizabeth,
When did Philip Elizabeth purchase the property?
1964, madam. 1964.
Philip Elizabeth purchased in the year
1964, madam.
40/5 was purchased. No,
May I make a
not
submission?
40/5B. 40/5 was purchased by Elizabeth.
Survey number 40/5, measuring 2 acres 39 guntas. Out of that, Philip Elizabeth was purchased only that 1 acre 29 guntas. 1 acre,
Total is
2 acres 39 guntas, madam.
2 acres,
39 gunta.
29. Okay.
And that mutation was affected in the 1968.
Okay, ivaga preliminary notification showed the name of who all?
No, the vendor's name was shown.
Show the preliminary notification.
A request. Lordship may kindly take my award at page 15 in the
Page 100
115 with, along with my memo of documents filed on 16 July 2014. Senior broadcast between Robert. Sir, I will. Later. I think.
July 24th.
Yes. Well, 16 July 2024.
Page number?
Lordship may kindly. The award page 15.
Next, sir, R2, my lords, the award.
Award page 15.
Memo, ಅದರಲ್ಲಿ notified ಖಾತೆದಾರ್ and ಅನುಭವದಾರ್ ಕಾಲಮ್ ಅಲ್ಲಿ I have shown ಪೊನ್ನು ಅಪ್ಪ ಒಬ್ರು, ಆಮೇಲೆ ಎಲಿಜಬೆತ್ ಫಿಲಿಪ್ ಇಬ್ಬರದು ಹೆಸರು ತೋರಿಸಿದ್ವಿ. ಆಮೇಲೆ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲೂ ಪೇಜ್ 119 of the writ petition, in that survey number 40/5 ಗೆ I have shown both these names in the notified ಅನುಭವದಾರ್ಸ್ and ಖಾತೆದಾರ್ಸ್ column.
Okay, amount ಎಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಆಗಿದೆ?
The amount is deposited in the civil court.
What has happened? Who has withdrawn it?
Lord, that detail, Lord, is not available with the BDA. Will reference code documents will have to be checked.
Award has been deposited.
Award amount has been deposited.
Okay, sir, it was speculative litigation.
One submission.
You have made only, it's a speculative litigation. Sir.
May make submission. Now that as per the provisions of the Land Acquisition Act, that
You go sue your vendor, sir. You go sue your vendor.
the survey number 40/5.
Possession was taken when, sir?
Lord, possession was taken on 10/11/1986, Lord. By
Layout
the
is formed,
layout is formed. Layout. No. But layout, insofar as this layout.
What layout?
Lord, this is Hennur Road, Ballari Road, Lord.
HRBR.
Yes, actually. Even the 3-member committee report, where that is the survey number 40/5A and B. That's layout is not formed by that, sir. That is the 3-member committee report, that's where that is. But that one submission by that. Here, that as per the provisions of the act, as per the provision of the act, as on the date of the issue of the preliminary notification, there was no property existence, survey number 40/5. But that's the mutation was affected. And also that in the revenue records, I have produced the revenue records also 1977-78. That I have produced the revenue records along with this document, shows that Philip Elizabeth that the 40/5A and 45B divided. But that's here, peer issue of notification in a wrong number, but which is not in existence as of the date. They cannot. We are mentioning the name is not sufficient. The property was not identified. Your Lordship kindly peruse the page number 125. That's the boundaries are not identified. And your Lordship kindly peruse that's the
Final notification torsi, sir.
Please, madam.
Final notification torsi.
Final notification, that is 125, madam. Page number 125, madam.
Can you verify and state
Yes,
whether compensation has been taken or not
I will do that.
by afternoon?
But
We'll
because-
order a criminal prosecution of her vendor. If compensation is taken by this Matthew or whoever, we'll order criminal prosecution of that particular person. Okay, and also give liberty to him to proceed against her to recover damages.
Yes,
But in the
but
meanwhile,
one more,
Man and known to law.
before that,
Hmm.
let me say, my lord, one fact, my lord. They participate in the acquisition proceedings, they participate before the land acquisition officer. May I request your
She
lordship?
comes, is it? That is sufficient. Where is it? Where is it?
Yes,
Show me.
may I take your lordships to kindly take page 19, the objections filed by them are produced from that along on the memo itself. Lordship may kindly take note from page 7 onwards. The notified khatedars participate. Page 7 onwards, not along with. I have produced the objections filed by them.
the meanwhile, the filed suits are declared by the entire area, 40/5B A, and 40/5B.
But those suits.
Okay, once again, 115, sir, where serial number?
Lord, serial number 30 in the final notification, 32. Let's agree to.
Thirty.
30.
Then where is this one? Participation?
Participation, Lord, the Lordship may kindly take, Lord, my memo along with the documents which I had filed.
47.
The 47 Allah, either the 16 July 2014, I'll pass on. Lord, may I pass on this, Lord, an additional copy?
One second, wait.
Yes. Lord, page 7 in that memo, Lord. Lord, these are the people. They,
No, where is this Elizabeth coming in?
Elizabeth, Lord, from Elizabeth, Palaniammal had purchased. From Palaniammal, he is.
Is it so?
From Elizabeth, Palidammal, that they have purchased the property,
And from them,
and subsequently,
My lords, internal,
I have purchased the property.
internal page 5, the award proceedings,
Page 5 of?
internal page 5. The award, where the award is concluded. Commences from whereas an extent of land, survey number 40/5, measuring 2 acres 39 guntas
Where is it, sir? Internal page 5
of the award, my lords. The award, annexure R2 of the BDA's objections,
filed on?
filed on 15/6.
memo ದಲ್ಲೇ
I'm told it's produced along with the memo now.
ಅದು ಅವಾಗ್ಲೇ ಮೆಮೊ ನೋಡಿದ್ರು ಅದರಲ್ಲಿ ಆ ಮೆಮೊದಲ್ಲಿ
That's they have produced the award copy. In award copy, that page number. Internal page number.
Page number 6 at the bottom it's recorded.
No, this page number 7, it pertains to only 40/5A.
No, my lord.
So these are the,
My lord, the page number 6 at the bottom, my lord, last paragraph. Page number, internal page 6, last paragraph, my lord,
Page number 6
of the award itself. Internal page 6.
of ಯಾವಾಗ ಏನ್ ಹಾಕಿರೋದು 4724 4724 ಹಾಕಿರೋದಾ?
ಅವಾಗಲೇ ಅವಾರ್ಡ್ ನೋಡಿದ್ರು ಪೇಜ್ 22 ತಾವು ನೋಡಿ ಆ ಅವಾರ್ಡ್
So you file this on this document 4724 thing.
16 ಹಾಕಿದ್ವಲ್ಲ 16 ಹಾಕಿದ್ರಲ್ಲಿ
16724.
ಹೌದು
Which page you want me to go to?
ಅದರಲ್ಲಿ ಪೇಜ್ 22 ಫಾರ್ಮ್ ಇದರಲ್ಲಿ ನೀವು ಬರ್ತಾ ಇದ್ದೀವಿ ಪೇಜ್ 22 Not, the last portion, what the learned AG wanted to read. This survey number has been subsequently coded into two hissas, that is so and so. As per the IL extract obtained from the Tahsildar Bangalore North Taluk, Khate of survey number 40/5A stands in the names of Sri Gubbi Ramaya and Sri Elizabeth Philip, and the Khata of survey number 40/5B stands in the name of Mani, Palaniyammal, Raja Marimuttu and Malayammal. As per the RTC, Sri Ramaya is the cultivator of survey number 40/5A. Srimati Papamma, Lakshmi, Saroja and Mani, Palaniyammal, Raja Marimuttu and Malayammal are cultivators of for survey number 40/5B. As per Form 7 extract, the land is free from tenancy. In the absence of so and so required documents, original the award amount cannot be paid to them. Is what has been observed. Now, what has been now contended is, Lord, that his vendor had a right in 40/5B, but as per the IL records as stood on that day, his vendor had a right in 40/5A. Vendor's vendor. And even otherwise. Nice. Either way, the entire extent is notified and possession is taken. 16(2) is also issued. He cannot come and say now that, Lord, my vendors did not have a knowledge of the acquisition proceedings. Lord, it is the vendors who participated in the acquisition proceedings.
Did you get did you apply for BDA to verify that survey number 40/5B has not been acquired? And did you get such an acknowledgement when you did due diligence?
But I have not verified because when the notification itself is a defect, when there's a 40/5A and B, that your lordship kindly peruse the.
Yes, where is your sale deed, sir?
I have produced the sale deed, annexer. Well, the annexer. Annexer A, the typed copy, madam. Page number 31, madam.
Page number 31 of?
That is readmission, madam. Page number 31 of readmission. That's the second paragraph. Whereas the vendor is the sole absolute owner of the land known as the survey number 40/5B in Hennuru village, Bangalore North Taluk, 1 acre 19 gutas, more particularly described in the schedule hereunder. Hereunder the schedule property.
1 second, wait.
Para number 2, that's a typed copy, page number 21. And also the schedule, at page number 33. 1980 they purchased. I have purchased the property from Palayanammal, that's annexure C, that's 1964, page number. Page annexure C, page number 75.
Final notification ಯಾವಾಗ?
Final notification 1970. 1977. 77. Well, my, your lordship kindly peruse.
1977,
Oh, 1977. Your lordship kindly peruse that I have produced the documents along with the list of the documents that the original signed in 1964. I have produced the document, page number 8, not in this manner. Additional documents I have produced on the, along with the map, plan and other things, OD and other documents.
One. First kind permission. Page 52 of his writ petition. There seems to be. But a typed copy of the partition deed is produced.
There was a partition. There was a partition. I have produced a partition deed also.
One nimsha. Partition deed shows partition between one Chellamuthu and his siblings. In that
Among his
document,
family.
it is clearly stated that the property in question, which was partitioned, was acquired by the predecessor, the father of the co-partners in the year 1980, 23rd August 1980. So Palani Ammal, his claim that he purchased it from Palani Ammal. Palani Ammal also comes into picture only after the process of acquisition is concluded, my lord.
Not like that, my lord. Lordship 1964.
NIM document.
1964, the Elizabeth Philip was purchased the property from Hanumathappa and others. And subsequently 1969, 1968, 30/11/1968, mutation was effected, Tata changed, and subsequently it was coded in the 1969.
Yes.
Revenue records, that I have produced the RTC extracts also, that her name was shown, that it was divided 40A and 41B. 41A belongs to the Kubbi Ramanna and it belongs to the Philip Elizabeth. When my property, my land was not shown in the alleged notification.
Yes, sir.
The 40/5B, if it is coded subsequently, I have no case, my lord. I agree it. It was earlier, more than 10 years. 1968, 77, their notification. Revenue records shows that there was a subdivision. I have produced the revenue records, my lord. The lordship may direct the government to produce the entire register. It is in the third floor of the, Kandai Bhavan. It can be shown that clearly. That's a.
Sorry.
We are mentioning that is a survey number. Without, your lordship kindly see that the boundaries are not tallying.
No.
Property is not, your lordship said it.
I'll come back in 5 minutes.
Please.
I'll just come back in 5 minutes.
Play.
ಮುರುಗೇಶ್ ಕೇಳ್ತಾ ಇದೆಯಾ? ಸ್ವಲ್ಪ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ತೀರಾ? ಮುರುಗೇಶ್ ವಾಯ್ಸ್ ಕೇಳ್ತಾ ಇದೆ.
In response to notice paper publication,
ಸರ್ ಹೇಳಿ ಸರ್.
claim application.
ಮುರುಗೇಶ್ ಚರಾಟೆ ಏನೋ ಟೈಮ್ ಕೇಳ್ತಾ ಇದಾರೆ ಅಂತ ಇದ್ರು, ಒಂದ್ ಸ್ವಲ್ಪ ಅವ್ರನ್ನ ಮಾತಾಡ್ಸಕ್ಕೆ.
ಯಾವ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಸರ್?
ಸೀರಿಯಲ್ ನಂಬರ್ 46 ಇದೆ, 47 ದಲ್ಲಿ ಮುರುಗೇಶ್ ಏನೋ ಟೈಮ್ ಕೇಳ್ತಾ ಇದಾರೆ ಅಂತ ಕೇಳಿದ್ದೆ.
47 ಅಲ್ಲಿ ಇಲ್ಲ ಸರ್. ಇದೆ.
ಅಲ್ಲ, ಅವ್ರು ಇದಾರ ಕೇಳಿ, ಅಲ್ಲೇ ಇದಾರೆ.
ಸರ್ ಸಚಿನ್ ಅಪಿಯರ್ ಆಗ್ತಾರೆ, ನಾನು ಅಪಿಯರ್ ಆಗಲ್ಲ ಸರ್.
ಹೌದ್ರಾ? ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಅಪಿಯರ್ ಆಗಿದ್ರೆ ಅದಕ್ಕೆ ಕೇಳಿದ್ದೆ.
ಪ್ರೋಬೋನೋ ಸರ್.
ಓಹ್, ಏನು ಎಲ್ಲ ನಮ್ ವಿರುದ್ಧ ಒಟ್ಟಾಗ್ಬಿಟ್ಟಿದ್ರಿ.
BS ಸಚಿನ್ ಸರ್ ಅಪೇರ್ ಆಗ್ತಾರೆ.
ಆಗ್ಲಿ ಥ್ಯಾಂಕ್ ಯು.
What officer?
Civil total.
Yes, argue, sir. You argue on rights of subsequent purchase. You argue on rights of subsequent purchase.
In this case, the petitioner cannot be a subsequent purchaser. The reason that may not deserve, even there in award, that's a page number. In award, at page number, I think that's a page number 17, they mentioned this page number. This, where your lordship kindly the survey number has been subsequently coded and it was wrong. The finding given by the award copy is wrong. My lord, there's a as per ILR extract obtained by from the Tahsildar, Bangalore North Taluk, the Kata stands that 40/5A stands in the name of Gubbi Ramaya and Mrs. Elizabeth. And Kata number 40/5B stands in the name of Mani and Palinamma and others. Your lordship kindly peruse that they have produced a document where that is a 1964, that is date of the purchase of the property that was there. 1968, 30/11/1968. It was coded. It was the mutation was affected. Coding was done 1969. The index of the land records, it is their names were appeared. That's a 40/5A and 40/5B was appeared, and subsequently that's in RTC extracts. RTC extracts also it is mentioned that is a 77, 78. That's it was divided by 40/5A and 40/5B. That was there, and subsequently I have purchased. That's my vendor was purchased in the 1980. My vendor's vendor was purchased. There was a partition among them. That's annexure B for the partition deed. Annexure C is where I have purchased a portion of the property. The usual property is a portion of the property that is a 40/5A.
How much you have purchased?
That's 4,000 square feet I have purchased only. It is restricted only that 4,000 square feet, not the others. But that's it. Entire 40/5B was fully developed. Suits also filed. All the members are suits filed. Suits are decreed. Permanent injunction granted in favor of the revenue site holders. They are in possession of the property. I have also filed a suit. Wherein the suit was decreed. At the time, in the written statement, they have not stated anything regarding the allotment of this property in favor of the defendant, respondent number 5. And subsequently, I came to know that this property was allotted in favor of the 5. Within 15 days, your lordship kindly appreciate this fact. within 15 days, they have allotted the property. That's alternative sites. After they are demolishing the property, existing building, as per the law laid down by the this honorable court in John B. James in para number 69, there is no provision in the BD Act to demolish the property without due process of law. They cannot allot it. Your Lordship, that's where Your Lordship, that's in the KL Ramesh versus that BD, the state of Karnataka. This honorable court clearly held that regarding the Maja, Your Lordship, they have produced the 2 Majas. That's name was not shown, witnesses were not shown, and that the property was not identified. When that is so, that is not identified. Even Gautam Hotel Limited, where that's in the head note A, that's when the particulars are not stated in the Maja, that automatically the entire acquisition proceedings is liable to be quashed. Your Lordship kindly peruse that. My portion is only 4,000 square feet. They have not demolished other properties, fully developed. Even 3-member committee report, 40/5A and 40/B, no layout is formed. That is the statement. Your Lordship kindly see that when as on the date of the issue of the notification, there was no such a property is existing. Even their own versions in the award, the Gubbi Ramaya name was not shown. 40/B. Your Lordship kindly peruse that page number 125, final notification. Final notification, at least they say that the total land is acquired on Tantara. Your Lordship kindly, that is a page number 25, where that is a survey number 40/5. It was shown column number 30. The boundaries given, 4 properties, they have given the same boundaries. Your Lordship kindly said that the same property. One day survey number, 4 property boundaries, one day boundaries. Where is the identification of the property? Your Lordship kindly said that preliminary notification as per the section where my learned friend said that that's section 17 of the BD Act. 17 of the BD Act, that's 5. During the, Your Lordship kindly said, during the 30 days of the next following the days, which is the notification published in official gazette shall serve notice on every person and the name appears in the assessment list or local authority or in the land revenue register as being the primarily liable to the property land tax bureau. Let them produce the document, the index of the land, where it is that they are not producing even a single piece of document. Your Lordship directed to produce the 4D copy. They have not produced it. I have searched the property. I have produced the documents. Where is the property? Survey number, when there was no such a property's existence, that how they can acquire it, my Lord, sir. Mere issue of the preliminary notification, mere issue of the final notification is not sufficient that the land is acquired. They cannot say, for example, for instance, that's the High Court of Karnataka, that's the entire High Court of Karnataka, one survey number, that it is divided into the KGD building. That it cannot be said that the KGD building is also included. In this case, also the same things have happened. Your Lordship kindly said that this fact is very important because not only my case, in several cases, they have the BDA, the land acquisition is misleading. Misleading. Several persons are suffering at the hands of the fake notifications because of their negligence. Not only this, there are several cases are there, my lord, in such circumstances. My lord, they identified one property, they demolished the property and allotted immediate to the VIPs. This has happened in this case at para number 12, where I have stated the grounds within 15 days.
Sir, listen, sir. You cannot get a better right than what your vendor had over the property. This is the first proposition of law. You cannot get a better right than what your vendor had. This is the first proposition of law, number 1. Now, with regard to your vendor, if they had not participated in the award proceedings, the case would have been different. Okay. Here is a case where, though it is shown as 45/5 in the final notification, notice has been issued to all the persons whose name found a place in the revenue records. And the name of your vendor as well as their vendor, they were also issued notices. Palani Ammal has participated in the proceedings. Elizabeth has participated in the proceedings. And compensation has been deposited. And you are not made due diligence while purchasing the property. You are required to, once the property comes within the jurisdiction of BDA, as advocates, we all know, we ask BDA, we ask the concerned DC office, we ask the KADB whether the land has been acquired or not. From BDA and KADB, whether the land has been acquired or not. From DC office, whether it's an SCST land. Any PDCL proceedings are there. See, these are must and should. Due diligence everyone have to do. Now, if you had shown, if records did not indicate that your predecessors in title did not participate in the award proceedings, then probably yes. And award proceedings everywhere references to 45(a), 5A and 5B.
5B. But there's a even to that country.
We can only sympathize with you. See, fraud has been played on you. See, either of the two things are. One is fraud is played on you by your vendors, or knowing fully well you have purchased the property on the ground that you will manage it with BDA. Unfortunately, you have not been able to. That's it.
Even then, the half the suit is decreed. Permanent injunction is granted.
Yes, sir.
Permanent is there. There's a section 38 of 38B of the BDA Act.
For BDA party to the proceedings in the said suit?
Yes, they have contested. They have led the evidence. After contest only they are sued.
What is their contention over there?
Their contention, that is the same content they have issued preliminary notification, final notification.
Now, what has the court said?
The court said that the plaintiff is in lawful possession and enjoyment of property, and the suit was decreed.
Bare injunction?
Huh?
Bare injunction suit?
Injunction, I have produced the copy.
Bare injunction suit?
Bare injunction suit.
Okay, anything else?
Bare injunction suit.
Yes, anything else?
There's the RFA is also filed. They have filed RFA. RFA is also pending consideration.
That's okay, sir.
Pending consideration.
Anything else?
There's a section 33 of the BDA Act. Section 38. Even the subsequent purchase is having a right. That it can be regularized. But I have produced the citations.
Section torse. Section odi sir, sako.
Section 38D, allotment of the Bangalore Development Authority land in favor of the original owner or purchaser or unauthorized occupant. Notwithstanding anything contained this act in any other law or any development scheme made under the act, but without prejudice to the section 38C, where the authority, after holding such inquiry as deems fit, is of the opinion that any land vested in or acquired by it cannot be used by it on account of existing building therein, and it is not practicable to include such a land for the purpose of the development of the scheme or formation of the sites. The authority may subject to such rules after holding such an inquiry as may be prescribed. Allotment such a land of the sale in favor of the original owner of the land or a purchaser from the original owner or any other person authorized for the land for the same reason or other who has put up a building on the land and it is settled in possession of the land, but it does not include the tenants. That is, the building is existing and settled possession also. That was the subsequent purchaser. Further, that is
D, because D also may have to be read. It is in a litigation position.
It is not a litigation position. Litigation was litigation
provided that Roman 4, provided that no such land can be allotted if in that plot clause B, the possession for more than 12 years is litigation or encroachment possession by virtue of the remote of the court.
My lord, there is here,
Is admission of the fact that I have demolished the property one, and admission of the fact that he himself has filed a suit against BDA and is in a litigated possession of the property, is also not entitled under 38.
No, that is different. It is not that against somebody else.
My lord, I'm saying 38B, a person who comes into an unauthorized occupation of the property, but for 12 years prior to the date of this notification, that is 2008, but if he is in a possession of that property by virtue of an litigation, but subsequently, not 38E is not permissible if he is.
my lord, there is a.
If his building is already.
What is the, ಹೇಗೆ the property ಈಗ photo ಹಾಕಿದಿರಾ?
But now they have demolished the property allotted to the defendant number 5. That is, there is no forcible disposal, even if I am there, that they cannot be disposed of. But right from 1924 pre-week council till today, that's there is no forcible disposal. His lordship in Dinanapa versus state of Karnataka, where the lordship clearly held that. But within 15 days, how they can tell it? But that's one submission.
Where is the photograph, sir? Photographs ಹಾಕಿದಿರಾ?
I have not produced by the photographs. I have paid the taxpayer receipts also produced. Taxpayer receipts and also all the documents have.
What is the judgment, sir, you are quoting?
Malad,
What is the judgment you are quoting?
Malad, that's a judgment. In case that is, even if it is a demolished, even a subsequent charge, D. Naranapa versus state of Karnataka, the state of Karnataka, where their lordship had clearly held that. Clearly is that once even the taking possession was not proved, Citation. Put it good, sir. Citation, what is good? Put it good. Sir, put it
Anything
good.
else, sir? That's all?
That's one. Even that's the ILR 2000 Karnataka, where the subsequent purchaser, that's a John B. James case versus John B. James versus where their lordship clearly held that in para number 60, where their lordship clearly held that is up.
In
2014. But there is a where that's in page that's I have cited that page number 39 regarding a forceful disposition. The last point arises for consideration whether the
page number?
Ink page number 39, madam. Ink page number 39. I have mentioned the ink page number 39, madam. That's John B. James case. The last point that arises for consideration is whether the direction should be issued to BDA not to forcible dispersion of the petitioner or not to demolish the structures in the sale in the sites claimed by them, claimed by the petitioner, claimed by them. Otherwise, than in accordance with the law. The petitioner contended that even a true owner, including the state or statutory authority, is not entitled to take a possession forcibly from the trespasser or is not entitled to take possession forcibly from a trespasser or unauthorized occupant. According to them, true owner can dispose a trespasser or a person unauthorized possession only having a recourse to law and not otherwise. Petitioner therefore contended that irrespective of the outcome of their challenges to the ordinance or their contentions based on the section 38C, there should be a direction BDA not to dispose of them, not to demolish their structure, otherwise that in accordance with law. On the other hand, BDA contends that as a true owner, it has a right to protect the possession, and such a right enables to entitle it prevent from any unauthorized unauthorized encroaching upon or trespassing into the land and occupying the land. Such a right includes the right to forcibly evict any encroachers or trespasser. It is also contended that as a statute right, it is vested with the right to take forcibly dispose unauthorized occupants of the encroachers. Having regard to the section 29, 33, 33A of the BD Act, section 8 of the Regularization of Unauthorized Constructions, Urban So-and-so Act. While referring to the illegal occupation or another portion of the BDA sought to make a distinction between the two categories, unauthorized occupant categories of unauthorized occupant. First, we are those entry into the occupation of the parties was illegal and whose occupation position subsequently became illegal on account of the cessation of the authority to continue to in occupation or position. Example, the lease so and so that. The second are those whose entry into the premises itself is illegal, and apart from the continuing being illegal encroacher trespasser upon the unauthorized structures in the land belong to others. He contended that forceful disposition by true owner is impossible in regard to the category of such persons. The aforesaid that the points for what the BDA statutory rights has right to forcibly dispose of the trespasser or unauthorized occupants of such a land by virtue of the provisions of the BDA Act. That's the red bit so and so.
Yes, BDA. Do one thing, by tomorrow, tell me who all have taken compensation. Can you verify and state?
What happens is the offender kept to the civil court. After that, are issued by the civil court, and their proceedings start. After that, our role gets limited unless until some enhancement is made. This conflict is not convenient to us, but then we would have filed an XML case. Most of the BDA enhancement, we have never filed an appeal challenging the quantum of the award. What proceedings would have happened is what the.
Can't you find out in the civil court? Can't you find out from the civil court what has happened? It's just that who all have received compensation, that's all.
Deposited and they have received, we will get the.
Who all have received the compensation? That's all.
Yes.
That's okay. If they have received compensation, that's the end of the matter.
According to that, not all these people come and pay. There is not the landowner comes.
Now, do you want to verify or not?
Faster. What we get here, civil court, everything would have got down. Earlier things are not even.
Okay, when do you want it?
In my effort, whether it is easily traceable or not, that may have it tomorrow. If it can be easily traceable, I will take it.
Not tomorrow, any other day. Before I got a partner matters.
Day after them. Heard in part for further hearing, call at 2:30 on day after. I don't verify, but only will close the matter.
Much obliged.
Who appears for respondent number 5?
Respond number.
R5.
Respond.
You have to be there day after tomorrow.
Yes.
You have to be there day after. Yes.
21. 2:30. Number 16. Yesu Misra.
Kindly grant us a week's time, my lord, we'll file our objections.
Yes.
Including applicant. including applicant in this matter. Lord, including applicant is education institution, to which the CA site has been allotted. And therefore,
They want some time. They want some time. The request of petitioner.
construction of school building is held up because of this.
When do you want it, sir? When do you want it, madam? The request of petitioner, call on date for it.
One submission.
28.
One submission. My name may be deleted. We can file a memo to that effect.
Registry to delete the name of the Narayan Swami VK as the advocate appearing for the petition.
26th, 28th.
26 holidays.
26th Raja, sir. Yeah, sir. Serve a copy, madam.
28, sir. 28.
26, I appear for. Adjournment.
Serial number 17.
17
SK
only,
Acharya.
sir. Date we were talking.
28, date. Serial number 17. SK Acharya, PV Chandrasekhar.
Alternative side.
Nana base of the petitioner. Provided. Here matter, Chandrasekhar. Last time ಏನಿತ್ತು ನೋಡಿ order sheet ಅಲ್ಲಿ.
Sought for my alternative site regarding land is acquired.
Nana base of the petitioner call on ನಾಳೆ date ಕೊಡಿ.
21.
ಬಂದಿಲ್ಲ ಅಂದ್ರೆ will proceed.
21/8.
ಯಾವ್ದು ಬೇಕು? ಆಯ್ತು 1ನೇ ತಾರೀಕು ನಾವು ಕೊಡಿ.
29.
29.
29. Serial number 18. Rohit Swami.
Petitioner, my lords.
Hmm.
I have served the copy on respondent. This petition, my lords, kindly see Annexure C. The petitioner's lands were notified in the years 1997 and 2006. After lapse of 25 years and 15 years, no final notification is forthcoming from the respondent authority. And no compensation, nothing has been deposited, my lord.
Yeah.
So I'm
Alright.
seeking to quash the preliminary notification.
No time.
I'm seeking to quash the preliminary notification, my lords. Our endorsement alle helidare swami, bari preliminary notification agide anta.
You are expected to get instruction counsel. Huh? Your
It's covered
senior
by
has-
judgment, my lords.
Your senior has appeared in these matters. In these types of matters, in any number of matters. Okay, your ordered notice. If you can't get instructions, don't take notice in the court. We'll blacklist you. If you can't get instructions, don't take notice in the court. Because of your incompetence, everybody has to suffer. Yeah, order sheet ಕೊಡ್ರಿ. ಯಾವಾಗ ಇವ್ರಿಗೆ notice ಆಗಿದೆ ನೋಡ್ರಿ. Yes, ಮಧ್ಯಾಹ್ನ ಕರಿತೀನಿ, ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ. Get instructions. ಏನ್ ಮ್ಯಾಟ್ರ್ ಹೇಳಿಯಪ್ಪ ಇದು? Tell me what is this matter? Tell me what is this matter? Quashing of what? What is the case of the petitioner? Tell me. Huh? Tell me what is the case of the petitioner? You are the contesting respondent. What is the case of the petitioner and why you are praying for time? Tell me that.
Regarding the preliminary notification.
Huh?
Regarding the preliminary notification.
ಇವಾಗ ಪೇಪರ್ ತೆಗೆದು ಓದೋದು. Why do you come to court? By afternoon, if you don't get instructions, I'm going to allow the writ petition. You call up Muda people and ask them. Final notification ಆಗಿದೆಯಾ ಅಂತ. ಏನ್ ಹೇಳಿ? ಈ ಲ್ಯಾಂಡಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಆಗಿದೆಯಾ ಅಂತ. If the answer is yes, we'll grant you time. If the answer is no, we are allowing the writ petition ಅಷ್ಟೇ. ಅಷ್ಟು ತಿಳ್ಕೊಂಡು ಬಂದು ಹೇಳ್ಬೇಕು. Pass over 230.
Alberts. 14%.
Government, if you can get the information, get the information.
Please, my lord.
ಯಾವುದು?
Respect of my lord, national is concerned, my lord, already approved. ನಾವಿಲ್ಲ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ, ನಮ್ಮನ್ನು ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅವರು. Respect of Mysore, my lord, Muda is concerned, my lord, there is a lot of judgment lordship passed regarding final.
ಗೊತ್ತಪ್ಪ, ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಆಗಿದೆಯಲ್ವಾ ತಿಳ್ಕೊಬೇಕು.
Please, please.
ಫೋನ್ ತಿಳ್ಕೊಬೋದ?
Please, now.
ಅದು ತಿಳ್ಕೊಳಕ್ ರೆಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ನಾವ್ ಏನ್ ಮಾಡೋಣ?
Please.
See, it is sheer incompetence of the advocate which results in granting time. Yes, what is this matter? 14%.
13%, 19.
Regarding the authority,
You already know because at your BS it was adjourned on the last occasion. Can you be a bit louder? Switch on the mic.
I'm sorry, madam.
Ah.
4.5 acres of land spread across 4 different survey numbers. The committee recommended deletion, my lords. However, my lords, the BD has written to the state government recommending that these lands are needed for the acquisition and will form the layout, my lords. It is that correspondence from the BDA to the government, my lord, which is under challenge before your lordships, my lord. Now the government will have to take a decision on whether, my lords, the recommendation of the BDA to go ahead with the acquisition or not will be accepted or not. Section 16(2) has been passed, possession has been taken of the property. Since it's a substantial piece of land, my lords, the question of that being a island and therefore might not be suitable for acquisition may not arise because 4.5 acres by itself, my lord, can be used for the formation of the layout. Now, my lord, the question is, two, my lord. One is the internal correspondence between the BD and state is subject to writ jurisdiction considering the fact that the state is yet to take a decision on the matter. One, second, my lords, if the decision of the BDM, my lords, is not acceptable to the petitioner, my lord, an appeal will have to be filed, my lord, because the earlier round of litigation was done by the learned single judge, my lords. Because all the recommendations of the committee are being challenged before the division bench, my lords. Because the learned single judge, my lord, his lordship Justice Arvind Kumar, in his order itself says that once the committee gives its recommendation report, then it is up to the BDA to see whether it wants the land or not. Eventually, my lord, the recommendation of the committee is not binding, it's not mandatory, my lord, it's only recommendatory in nature. Now, my lord, we say, my lord, that we need that lands. That is the challenge.
Your Honor, that.
One second, I'll come to you. Within how many days you will take decision?
See, this is only what was impute order annexure A is, my lordship, internal communication between the.
Within how many days you will take decision? We'll direct you accordingly.
Problem, difficulty, my lords, is this. The overall decision, my lord, will overall once decision about this from the state. They might not be taking it on a piecemeal basis.
What do you mean by piecemeal?
And overall lands which will be recommended for either to let go of the lands or to go ahead with the acquisition, it might be done at once. So it might not be done on a survey number basis, as in when the recommendation comes from the committee.
How much time the state wants? You can't put the owner of the land.
Page number 84, my lordship, kindly report that. The 7/2/24, my lord. This is.
ರೀ ಇನ್ನ 8 ದಿವಸ ಬೇಕ್ರಿ ನಿಮ್ಗೆ ಡಿಸಿಷನ್ ತಗೊಳಕ್ಕೆ, ಅಷ್ಟೇ ಪ್ರಶ್ನೆ ಇರೋದು, ಬೇರೆ ಅಲ್ಲ.
Time frame.
ಅದನ್ನೇ ಕೇಳ್ತಿರೋದು, 8 ದಿವಸದಲ್ಲಿ ಡಿಸಿಷನ್ ತಗೊಂತೀರಾ?
6 months.
Why 6 months?
This is only internal communication.
That is different. To take a decision whether to accept the recommendation of BDA or go with the committee's
Reasonable time maybe. Reasonable time.
4 months I will grant you.
3 months.
Your Honor, may I make a
Hey,
suggestion?
3 months. Neither 3 months, 3 months.
Allah, they have also
Okay,
filed a
because-
Mister, it's like this.
May I please draw your attention to Annexure D, which was an order passed by yourself, wherein you had granted them 2 months to pass a decision. Now, more than 6 months are over, they have still not taken a decision. We are back to the same square one where we were 7-8 months ago. At page 108, Honor. This is an order passed on the 7th of February. I had already approached this court, seeking a writ of mandamus, directing the BDA to act. They had already been sitting on the report of the Justice Stationery and Committee for more than 1 year. They had not taken any decision. The BDA had.
Same land,
Yes, this is the same matter. The same matter had already approached this court.
Come to Annexure D 108.
Not there. Now we have written to the state government, my lords. Now the learned petitioner, my lords, has filed a contempt on the non-compliance of this order. No, my lord, the order stands complied. No, my lords, it's for the state to take a decision.
Your Honor, my submission is this. When the committee was set up, the direction that was passed was that it was the committee which would be empowered to decide on which lands would be deleted, which lands would be continued with.
But
The
it's,
BDA was stripped of all rights thereafter.
no,
that's incorrect.
I see the
I will take you through the
this
order that-
decision of the committee are recommendatory in nature.
That is correct. But this is to be read with what the Supreme Court has also directed in regard to Kempapura village. The Supreme Court, Your Honor, I went before the Supreme Court. The Supreme Court said this is not what is called planned development. You cannot take these tiny little bits of land. That is not what is called planned development. And the Supreme Court then directed the BDA to reconsider the matter and file a fresh report. In that fresh report, they disregarded everything that the Supreme Court said, and they said we're going ahead. I challenge that. That decision by the BDA to form a layout has been quashed and set aside. So where is the question of them wanting to form a layout in Kempapura at this point in time? This was decided 15 years ago. At this stage, they still say we want to take land 2 acres here, half an acre there. That is not what is considered to be planned development at all. And that has been set aside by this court. If I may take this, if I may draw your attention to page 252. In writ petition 35573, if I may take it to page 267 of that order.
You didn't file contempt, is it? You did not file contempt, is it?
It's
No,
been
no, I
filed
had
and
filed
pending,
contempt because after 10 days, they were required to give me a copy of that order. They did not give me a copy.
No.
The commissioner refused to give me a copy, saying the court has not directed me to give you a copy. You do what you want. So I filed under RTI, and that's how I got a copy of this on this particular.
Okay. Now, after filing contempt, what happened?
You know, that matter has not yet come up. That had to do with them furnishing me a copy of that order, which they have recently passed. That has not yet.
Annexure A is passed when?
You know, this particular order was passed in 2018. What had happened, Your Honor, was that the Supreme Court had directed that the BDA take a fresh decision with regard to Kempapura village. They took a fresh decision, but they didn't give.
No. Annexure A was passed when?
Beg your pardon.
Annexure A communication.
Annexure A was passed on the in February of this year, on the 1st of March.
After the recommendation, my lord. After the recommendation of the committee,
For the equal direction.
the BDA says, my lord, that it needs the land. The argument of the island, my lord, would be available for the petitioner, my lord, if it's a small portion of the land, 20 guntas or 10 guntas, or even assuming for 30 guntas or 1 acre. It's a 4.5 acres land, my lord, subject across 4 survey numbers adjacent to each other.
No, that is different altogether. See, in the light of the order passed by this court at Annexure D.
No, my lordship, that is considered in page number 84 in the
That's
communication.
Annexure A, my lord.
Annexure A, page number 84, kindly see. Last para 2.
Fine. See, there are two orders passed in the earlier petition. You come to page number 111 and 112. See, 111 and 112. See what happens, the first portion of the order has been complied with by the BDA. Either positive or negative. Now, after receipt of this particular communication, state is required to act. Within 2 months thereafter. You are not challenging this particular order. It has attained finality. No, you have to act forthwith. That's why I'm asking, when was Annexure A passed?
Sir, A, my lordship, kindly see. I have referred that order, my lordship.
Annexure A, my lord, is 1/3/2024, my lord.
Huh?
1/3/2024.
Then 1/5/2024 order, government ought to have passed an order. Where is the question of granting any further time?
lord, in respect of what happened, my lord, earlier, my lord, occasion, my lord, they give file the petition based on the report. And PDF meanwhile, my lord, PDF for the other reports regarding, land is required. Earlier, they file the petition based on report, this is, the report is based on report, my lord, the lordship pass an order to.
See, listen. After this order has been passed. This order is 7th February 2024.
Please, my lord. Thereafter, my lord, the. PDF
Annexure A has been passed. Okay, they were required to act within 10 days. You are required to act within 2 months thereafter. Take a decision forthwith.
Your Honor, if I may make a submission. During the previous hearings, if you may turn to Annexure Z, which is at page 395. The communication that the BDI had earlier written to the government was that we intend to withdraw from the acquisition. We are requesting you to issue a notification under section 48(1) of the Land Acquisition Act. That was placed before this court in the previous proceedings. At that time, the representation that was made by the BDI was that we require 10 days because the government has written to us and asked us for some clarifications. The government then made a representation that we require 6 months in which to issue the final notification. At that time, you said you will grant them 2 months to do that. Now they have made a complete U-turn. Now they are turning around and saying, we're not going to delete the lands at all. The previous representation that was made here was that we are proceeding with the deletion. We are asking for a notification by the government to be issued. Now the latest order says that we require the land, we're going to continue. And the reason that they say they require the land is because they claim that the land acquisition procedure is completed. They say that the land vests in the government. But that has already been determined by this court more than 8 years ago. The order that they passed taking possession was at a time when there was an interim stay against them. They could not have done that. That has been already decided by this court. So what is happening is that they're regurgitating all these old issues over and over again. And the fundamental issue is this, Your Honor. When the Supreme Court has said that you cannot form a layout in Kempapura village specifically. Why? Because I went before the Supreme Court. If I may show you the map of Kempapura village, essentially it is only my land that is left. All other lands have been deleted. There were 55 acres at the very beginning. That came down to 26 acres. From 26 acres today, it is under 8 acres, of which 4 acres are manned. The balance are little parcels of land, which they now say they're going to delete in this very same recommendation. So they are now targeting me, Your Honor. I'm sorry to say this, but they are unwilling to follow what are the directions of the court. This issue is more about why is it that they cannot follow what the courts are directing them to do. It is not a matter of 2 acres or 3 acres. When the Supreme Court says planned development is not about you going and taking half an acre there, quarter acre there. Each of my lands are tiny pieces of lands. They're completely surrounded by lands that have been deleted. And I approached this court 20 years ago. I showed this court that I've been discriminated against. So I have succeeded on Article 14. I'm now being held to hostage under Article 21. Under Article 300A, whatever the court tells them to do, they do the complete opposite. That is where we are today.
My lord, these grounds, my lord, would be available to the petitioner, my lord, if the state on the recommendation of the BDA still decides to go ahead and allow the go ahead for the acquisition. These would be good grounds, my lord. My respectful submission is, my lord.
Your Honor, may I take it
as
in the
on this
language
date,
of what was written
as on this date,
when
my
the
lord,
committee was set up. When
the
committee
petition
was
is
set up.
premature, my lords, because state is the acquiring authority. State may either accept my acquisition recommendation or it might refuse it. If it refuses, then my lord, the land will stand denotified. If it
Filed your objections for the notifications?
Yes, I filed objections.
You filed objections to before the BDA.
Preliminary notification. I filed a writ petition. I was part of the writ appeal proceedings. I went to the Supreme Court. I filed an SLP.
No, that is different. I'm asking you, after preliminary notification, did you file your objections?
I filed my objections. I participated in the proceedings over there.
In the proceedings also. Your objections are on record. His
Yes.
objections are on record.
His objections are.
We'll do one thing. We'll adjourn it by 3 weeks. By that time, let state take a decision. You will have to forward his objections also to the state. State will have to file a report why it has taken a particular decision.
Please.
Okay, we'll keep this pending.
Now, if I make one last submission.
See, counsel, it's like this. I mean, sorry, party in person, yes. See, mister, it's like this. Until, strictly speaking, your writ petition is premature. Because pursuant to the earlier order, you are required to probably file contempt. I'm not advising anything.
Which has been done, my lords, which is pending. Contempt is pending.
Okay, that is the correct course of action. this writ petition becomes premature. Because final decision is not yet taken. Once final decision is taken in your case, yes, BDA might have recommended to the contrary to of your liking. But ultimately it is for the state to take a decision. Your right fructifies only upon state taking a decision.
Your Honor, my last submission is pertaining to that very point. My submission is that the directions of this court in setting up the committee was very clear. It stripped the BDA of any right to decide on this.
It did not. The recommendations of the
language
committee,
of
the recommendation of the committee are recommendatory in nature. It is not binding on the BDA as such.
Your Honor, if you may please turn to page 744. This is now the order that was passed in writ petition 51929.
I intend to adjourn it by 3 weeks. Let the state take a decision. Then you get a fresh cause of action. Yes, Bunny. At the request of AGA, call on, get to it. 3 weeks.
4 weeks, after 4 weeks, the date will fix after 4 weeks.
15 ದಿವಸ ಕೊಡಬೇಕಿತ್ತು. You are in clear contempt of the earlier order, I see. 3 weeks ಬಿಟ್ಟು date ಕೊಡಿ. Tenth, yes. 10/9. The state is directed to take necessary decisions as per the directions of this court. See, if I pass this order, your contempt petition may go, I don't know.
Your Honor, I'm happy to withdraw the contempt petition because it was only because they were not giving me a copy of their order. The first order the first part of the direction, it was only for.
Dated 7/2/2024, my lord.
In WP number 27329 of 2023. By then. By then. Mister.
Your Honor, a copy may be served on me before the date.
Call on. 10/9. A copy.
Rajib can pass the direction to the state to consider this recommendation.
What?
Act upon the committee report.
Mister, ಆಗ್ಲೇನೆ ಆರ್ಡರ್ ಆಗಿದೆ ಅಲ್ರಿ.
Clear this.
ಮತ್ತೆ ಯಾಕೆ ಆರ್ಡರ್ ಬೇಕು? You pass it and come back. Yes.
Obliged. 20, Giri Kumar SV. Giri Kumar.
The certified copy of this order shall be made available to the learned AGA free of cost.
Please.
Small accommodation, my lordship.
For respond number 1, my lord.
Yes. Ready ಇದೀರಾ ನೀವುಗಳು?
Yes, ma'am.
Short.
For respondent 3, my lord.
ಯಾವಾಗ ಬೇಕು?
Next week ಅಲ್ಲೇ ಯಾವ್ದಾದ್ರು date.
The request of petitioner, call on. Date ಕೊಡಿ.
28.
Please.
28.
28. Number 21 adjourn. Number 22 Vaishali Agde. Ashok N Nayak.
22, my lord, we are filing an application for amendment. Without the copy, that is, my lords, regarding the award. Though the acquisition is, my lords, of 2013, till we filed the writ petition and till 2018, no award was passed. During the pendency of the writ, an award, unilateral award has been passed, my lords.
ಕೊಡಿ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇವತ್ತು ಕೊಟ್ಟಿದ್ದೀವಿ ಕಾಪಿ.
ಇವಾಗ ಸರ್ವ್ ಮಾಡಿ.
Permits will file it.
ಮಾಡ್ಬೋದಾ? You want to file objection?
We are saying 2000.
Go into it, my lord. Verify.
At the request of parties.
Registry file ಮಾಡದ ಇಲ್ಲೇ ಕೊಟ್ಟಿಲ್ಲ.
Registry file ಮಾಡಿ.
Please. I've served a copy.
1 week bit date ಕೊಡಿ.
1 week, 28.
28.
Serial number 23, Subhash Shastri.
Lords, I appear for response possible. Can I request my lords to kindly see the order sheet, Lord, they are not coming at all.
ಕೊಡಿ.
The last name.
Last time,
None appears to the petitioner. Even on the last date of occasion, none appeared for the petitioner. Even on the last date of hearing, none appears for the petitioner. The writ petition is of the year 2014. It appears petitioners are not interested in prosecuting the writ petition. The writ petition is dismissed as infructuous. Sorry, it is dismissed for non-prosecution.
24 adjournment. 25 Sarath S. Gowda.
Not kindly pass over.
Pass over.
Sir, if it is.
26.
Seek for accommodation, Lords, pass over. After minutes.
The request of respondent number 2, call on date to 25.
20.
Daud Becker,
Any date after that.
29th.
29. Number 28 KK Vasant.
26 ಏನಾಯ್ತು?
26. 26 KK Vasant.
26.
Ah.
My call next week. Next week or first week of.
The request of petitioner, call on date ಕೊಡಿ ಒಂದು. First week.
30 38. Number 27 Harish Bhandari.
Lord, in this case, petitioner challenging internal communication, my lord. Petitioner, my lord, wrongly dispersed the amount and taken false certificate has been produced and dispersed the amount, my lord, received the
No,
amount
so non-prosecution ಮಾಡಿ.
last time.
Yogesh D. Nayak.
ಗೊತ್ತಲ್ಲ ಹೇಳೋದು ಮಾಡೋದು.
Dismiss for non-prosecution. 28 SR Joshi.
I appear for respondent number 2. In this matter, petitioner is seeking compensation, disbursement of compensation, and he claims to be power of attorney holder. But my lord, compensation has been paid to executant of power of attorney, and petitioner has given no objection. So I'm just producing the document. So my lord, this petition doesn't survive, my lord.
I'll pass it over, call at 2:30. I'll dismiss it at 2:30 if they don't come. Pass over.
Obvious.
29 Rakshita DJ. Narendra Gowda.
I appear for respondent response. Then connected mallards with regard to similar facts. I am told 3 or 4 matters are coming up tomorrow.
ನಾಳೆ ಬೇಕಾ?
ನಾಳೆ DL Jagdish ಅವರು.
None appears to the petitioner at the request of respondents called tomorrow. ನಾಳೆ date ಕೊಡಿ.
28. Number 30 M Narayan Bhatt.
My lord, appear for the petitioner, my lord. I will physically come in the afternoon and I'll do it, my lord, 2:30.
Pass over.
Next week, my lord.
ಯಾಕೆ?
I want to file objections. It is the GST matter, my lord.
PDAಗೆ ಟೈಮ್ ಬೇಕಂತ. 29th ಹಾಕ್ಬೋದಾ ಭಟ್ರೆ?
Swami.
The request of respondents call on 29th.
31 Samir SN Ajay Kumar.
My lords, rest time, my lords. This matter is pertaining to G category sites, my lords. There is a separate committee for this, my lords.
It is dismissed for non-prosecution.
PNP. Mahesh Vayal. Nagayya.
Please. ನೋಡಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿದ್ರ?
Both parties.
That's one submission.
Let him come.
May I make one submission? Notes at this honorable court had directed ADLR to do a survey, my lords, and submit a report earlier. He has in fact submitted a report, but as per the report, there's a discrepancy in the Akar Band extent in the Akar Band and RTC. May I request for a direction to ADLR, my lords, to do a survey in the presence of all the concerned parties and submit a report on this discrepancy, my lords. Because that would, my lords, throw some light on what the petitioner is claiming. He's now claiming 5 guntas, my lords. Now, because of this discrepancy, my lord, it could also be a case where there's no land at all what he's claiming. Therefore, my lord, may I seek for that direction?
Let him come. I'll pass over.
Could it be had tomorrow, my lords? May I request?
Not tomorrow. If you want, I'll give next week.
Please, my lords.
Next week I'll give.
Next week.
The request of, none appears to the petitioner at the request of respondents, call on 29th.
29th.
It's 28 minutes, may I request?
28th.
Great.
Serial number 33, Nagaya, B. Vachan.
Pay for the petitioner, my lords. Some ready.
I'm yet to receive the wakalat and instructions, my lord. Some time may be granted to file the.
When you want,
2 weeks, my lord, any date.
the request of
Even in the last
respondents.
occasion, they saw 2 weeks. time.
Wakalat in a
At
month.
least if interim order is passed, my lords, then.
Matter, I do not have anything in my hand.
Call on, date could you, 29th Madi.
Please, my lord, I'll obtain instruction.
Please.
Oblige, my lord.
34, P. Mayesha, case B. Maya.
For respondent number 4.
Sought for mandamus, my lord. Ready now.
After 2 weeks, madam, they have to file our wakalat. Copy ಇವತ್ತು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲೇ ಇದ್ರಲ್ಲ ಮಹೇಶ ಎಲ್ಲೋದ್ರು?
P. Mahesh. P. Mahesh.
None appears to the petitioner. Call on, date could
29. 35, Leela Raju MN,
The petitioners, your lordship.
Urgesh with Charati.
It's been 8 to 9 dates. The opposite has not filed their objections yet, your lordship.
What is this?
Lord, I
Your
recently
lordship,
filed.
I just have a small request. There is only marginal land which is of 800 to 1,000 square feet, which I want BDA to follow as per the writ petition. This is already filed. As per the directions, I had already made a fresh representation in 2021, for which they had replied after 1 year, 2023, when they sent the endorsement, stating that the representation which we made in 2021, the fixation of the rate as per the direction, previous writ petition direction was as per 2013. But the endorsement says we cannot fix the rate as per 1975, which was not what I asked in my representation, your lordship. Your lordship, I just seek directions to BDA so that they can file a fresh representation. For me, if the judgeship, but if the lordship may allow to file a fresh representation or direct the opposite to consider the 2013 as per previous petition order.
But the annexure J, this is the endorsement which has been issued by us. That is not even been challenged in the present writ petition. What we have said in the said endorsement, your request for reduction in the price of an allotment cannot be considered as there is no provision for reduction in the BDA Act. This is what is the sum and substance of annexure J. Now, my lord, again asking us to reconsider or making a representation for reconsidering the same, because there is no provision for reduction of the price when a marginal land is allotted.
Lordship, if you go to page number 37, my representation, I have, as per the direction of this honorable court, have made fresh representation based on the orders to file fresh representation, and for BDA also direction was given that 2013 fixation price may be considered. The same is in page number, Lordship, I'll just read out page number 35, as per the directions. The request of the petitioner, page number 35, your Lordship. The request of the petitioner to allot the marginal site, taking note of the price of 1975, would be unreasonable. Learned counsel for the petitioner submit that the petitioner would make one more representation requesting the BDA to recalculate, collect the value of marginal site as on date of application 2012. Hence, the following order. The petitioner are permitted to file fresh representation within 30 days from the date of receipt of this order. If such representation is made by the petitioner, the respondent BDA to consider the same along with representation annexure G. Your Lordship, I made representation in 2021 stating kindly reconsider as per 2013. But the reply what I received in page number 40, your Lordship, is that we cannot consider in 1975, as per that we cannot consider. There is a lot of lacuna in this reply. They have not read my endorsement. they have not followed the
ಯಾರ ಐಟಿ
direction of
ಕೊಡ್ತೀರಾ
this,
ಹೇಳಿ
Your
ಇಲ್ಲ
Lordship.
ಕ್ಲೋಸ್ ಮಾಡೋಣ.
Yes.
ಯಾರ ಐಟಿ ಮಾರ್ಜಿನಲ್ ಲ್ಯಾಂಡ್ ಕೊಡ್ತೀರಾ
No,
ಹೇಳಿ.
no, as on the date of the allotment, we will consider. Because
that is-
marginal land is not a land, they cannot claim it as a matter of right. It is not a matter of right. Lord, what has happened is actually this property measures more than 1/3 of an actual site. A decision has been rightly or wrongly been taken to allot the site. Lord, what has been now done is, as on the date of the decision, we have asked him, this is the prevailing value of the prevailing allotment rate, pay that much. Now, what has been now contended is in 1979, you may allotted me a original site. That is what the price at which I am supposed to entitled to get a marginal site. This court said that is unreasonable. Now they say in 2012, for the first time, I made an application for allotment of a marginal land.
Your Lordship, it is the direction in the previous writ petition, Your
Lordship, may
Lordship.
kindly
No, it is to consider.
consider, they say I will make an application by quoting the rate at 2012. The court said, Honorable Court said that if it is permissible in accordance with law, you consider that. We have said we have no provision for reduction of a price. That's all is annexure J is not even challenged in this, before this court.
Your Lordship, other than this also, they did not write in the representation. They have only mentioned about,
Okay, will you be satisfied if the present rate, are you willing to pay and take it?
Your Lordship, they may give us a fresh endorsement. May this be considered, Your Lordship, on the previous
They
application.
will
as per the
verify
direction.
and state. Will record it and close it. You're not understanding the severity of it. Any disposal without due direction, they will make you run from pillar to post once again. Ask your client if he is willing to pay the present rate. They will allot you. Will make that recording here itself and dispose it off so that they will be bound to give the marginal land.
Your Lordship, but there is no reconsideration at all. This honorable court itself has directed the opposite to reconsider in the previous, they had given us a quotation, Your Lordship. BDA had cited one figure, but that figure was asked to be reconsidered, Your Lordship. If at all that figure was not to be reconsidered, Your Lordship may have directed at that same point in the previous writ petition itself. Now they are coming back and telling us, we had quoted, there is no provision. May Your Lordship consider this fact at least that they had not mentioned it anywhere, that there is no provision in the previous writ petition, Your Lordship.
Yes, where is the consideration?
Annexure J.
Page 40, Your Lordship.
ಉಲ್ಲೇಖ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರೆಕ್ಪಿಟಿಷನ್ ಸಂಖ್ಯೆ so and so ನಲ್ಲಿ ನೀಡಿರುವ ನಿರ್ದೇಶನ ಮಾನ್ಯ ಆಯುಕ್ತರ ಸಂಖ್ಯೆ so and so. Marginal land itself is 40/25. Not the allotment. Marginal land is only 40/25.
And Your Lordship, it is in the western side of my plot, which cannot be used by anybody else.
Where is your representation subsequent to the order?
Annexure H, my lord. Annexure H, page 37.
Say I can dispose it off, directing them to consider this 29/10/2021 order. But that may not come to your rescue in any manner whatsoever.
Yes, Your Lordship. Your Lordship, I'm requesting only to direct BDA to reconsider the 2013 value. May I be allowed to make fresh representation on which they can send me an endorsement? This honorable court itself has guided me to make fresh representation.
You have not considered annexure H, which you are required to do so.
Not annexure H is considered.
No, it is not.
Lord, may kindly see, Lord. Lord, Annexure J may kindly be read. Yes. Lord, may I read the complete endorsement? Your lordships could permit me. Lord, ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹಿಂದಿನ CITB ವತಿಯಿಂದ ಬನ್ನೇರುಘಟ್ಟ ಬಡಾವಣೆಯಲ್ಲಿ ಸೋ ಅಡಿ ಅಳತೆಯ ನಿವೇಶನ ಸಂಖ್ಯೆ 46 ಶ್ರೀ ಅವರಿಗೆ ಹಂಚಿಕೆ ಮಾಡಿದ್ದು ದಿನಾಂಕ 10/9/2001 ಶುದ್ಧ ಕ್ರಯ ಪತ್ರ ನೋಂದಾಯಿಸಿ ನೀಡಲಾಗಿದೆ. ನಂತರ ದಿವಂಗತ ಹಂಚಿಕೆದಾರರು ವಾರಸುದಾರರಿಂದ ಸದರಿ ನಿವೇಶನವನ್ನು 2013 ಕ್ರಯಕ್ಕೆ ಪಡೆದಿರುವ ಶ್ರೀಮತಿ ಸ್ಮಿತಾ ಗುಬ್ಬಿ ಸೋ ಇವರ ಪರ GPA ದಾರರನ್ನಲಾದ ಶ್ರೀ ನಾಗೇಂದ್ರ ಗುಪ್ತಾ ಎಂಬುವರು 24/1/2018 ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಮನವಿ ಸಲ್ಲಿಸಿ ನಿವೇಶನಕ್ಕೆ ಹೊಂದಿಕೊಂಡಂತೆ ಲಭ್ಯವಿರುವ ಹಂಚಿಕೆ ಜಾಗವನ್ನು ಹಳೆಯ ಹಂಚಿಕೆ ದರವನ್ನು ವಿಧಿಸಿ ಹಂಚಿಕೆ ಮಾಡಿಕೊಡುವಂತೆ ಕೋರಿರುತ್ತೀರಿ. ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ಪ್ರಚಲಿತವಾದ ಚಾಲ್ತಿಯಲ್ಲಿ ಅಂತೆ 86.25 ಚದರ ಮೀಟರ್ ಹಂಚಿನ ಜಾಗಕ್ಕೆ ಮಾರ್ಗಸೂಚಿ ದರ ಪ್ರತಿ ಚದರ ಮೀಟರ್ಗೆ 91,200 ರುಗಳಂತೆ ಒಟ್ಟು 78,66,000 ಪಾವತಿಸುವಂತೆ 11/2/2017 ಹಿಂಬರ ಮೂಲಕ ತಿಳಿಸಲಾಗಿತ್ತು. ಹಂಚಿನ ಜಾಗಕ್ಕೆ ವಿಧಿಸಿರುವ ದರವನ್ನು ಪ್ರಶ್ನಿಸಿ ನೀವು ದಾಖಲಿಸಿದ ದಾವೆಯನ್ನು
29/10/21 ಇಲ್ಲಪ್ಪ.
ಇದೆ. ಆಮೇಲೆ ಕೆಳಗಡೆ 4/7/2022 ಇನ್ನೊಂದು ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಕೊಡ್ತಾರೋ ಪರಿಗಣಿಸಿ ಸೂಕ್ತ ಆದೇಶ ಹೊರಡಿಸುವಂತೆ ಪ್ರಾಧಿಕಾರ.
Where is the 4722 representation?
ಈ ಸಂಬಂಧ ನೀವು ದಿನಾಂಕ.
Where is the 4722 representation?
47.
That has not been produced. ಸಲ್ಲಿಸಿರುವ ಮನವಿಯನ್ನು ಪುನರ್ ಪರಿಶೀಲಿಸಲಾಗಿ ಪರಿಗಣಿಸಲಾಗಿದ್ದು so and so. Then again they asked there in 1975 ಇದನ್ನೇ ಕೊಡಿ ನನಗೆ ಅಂತ ಕೇಳ್ತಾರೆ.
In 2012, we made a representation, and 2018, we have made a representation. After that, we had filed a writ petition, your lordship. After that.
Have you made 4722 representation?
It is not produced, your lordship.
Should you not be challenging this order? Without challenging, how can you file a writ petition?
Your lordship, as per my representation, if I read it out, I have only.
Okay, you have taken a decision to allot marginal land, no?
Yes.
Yes, Bunny. Respondents are directed to verify and all respondents are directed to state at what rate they are willing to allot the marginal land to the petitioner as prayed for by next date of hearing. Call on. ಯಾವಾಗ ಹೇಳ್ತೀರಾ?
10 days. 10 days.
10 days ಬಿಟ್ಟು ಡೇಟ್ ಕೊಡಿ. ನಿಮ್ ಕ್ಲೈಂಟ್ಗೂ ಕೇಳಿ. They are agreeable for the rate, will direct them to allot at that particular rate.
Yes, your lordship. But your lordship, only one request. May you direct the opposite to consider the 2013 rates.
Madam, ಅರ್ಥ ಆಗಲ್ವಾ ಹೇಳಿದ್ದು?
I understood, your lordship.
I can do that and I can dispose of the matter. You won't get 1 paisa relief.
Understood, your lordship.
If you insist once again, I'll dispose it off right away.
No, your
No,
lordship.
I'll dispose it off right away. You want the disposal?
No, your lordship. Next
Bunny,
date, may they
the
come back
case
with
of the petitioner is, I'll dispose it off.
No, your lordship, next date may be given.
29.
And to put some quietness to the litigation, ask your client also to be practical. Ask your client also to be practical.
Much obliged.
Yes, Harish.
Number 27.
Can't help it, Harish. Twice you are absent, so it has been recorded in dismissal.
ಇನ್ನೊಂದು connected matter ಇದೆ ಅದನ್ನು submission ಮಾಡೋಣ ಅಂತ I was held up in the other court.
See, the point is when you are continuously absent, what can I do? The other side also was present over here.
ಅದರಲ್ಲಿ ಇನ್ನೊಂದು connected matter ಇದೆ. This is by husband, the wife to file the connectment. Kindly get it 38058 of 2017, your lordship. All together, your lordship.
ಆಯ್ತು, ಇದು 27 recall ಮಾಡಿ. ಬೇಡ dismissal. The request of petitioner, less the matter along with WP number so and so. ಬರ್ಕೊಡಿ.
WP number.
Call on, date ತಗೊಳ್ಳಿ. See, on that day,
Please, your lordship.
see, ಒಂದ್ಸಲ absent ಆದ್ರೆ I can understand ಅಪ್ಪ. Regularly you have been absent.
Absent ಆಗಿರೋದು.
28th.
28th
ಆಯ್ತು, ಬೇಕಾದ ಡೇಟ್ ತಗೊಳ್ಳಿ, ಅವತ್ತು ಅಪೀಲ್.
ಮ್ಯಾಟರ್ಗಳಿದೆ ಅವತ್ತು 28th ಗೆ ಆ ಪಾಠ.
ಆಯ್ತಪ್ಪ, ನಿಮಗೆ ಬೇಕಾದ ಡೇಟ್ ತಗೊಳ್ಳಿ.
30th.
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 Serial number 37, my lords.
Now we have received the statement of objections today, ma'am.
Shilpa Shah madam.
Yes.
The request of petitioner, call on.
Next week, any date, ma'am.
3739.
Serial.
37, ಒಂದ್ ನಿಮಿಷ, 37, ಯಾವಾಗ ಬೇಕು?
39.
39, 38 ಏನು?
ಆಗಿದೆ ಸಿ ರಾಮಕೃಷ್ಣ ಫಾರ್ ಆಟೋ ಆರ್ 3 ಆಗಿದೆಯಲ್ಲ.
Serial number. Serial number.
ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಅವ್ರು ಪದೇ ಪದೇ ಟೈಮ್ ತಗೊಂತಲೇ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. ಇಟ್ಸ್ ಎ ಮ್ಯಾಟರ್ ಆಫ್ ಏನು ಡೆವಲಪ್ಡ್ ಲ್ಯಾಂಡ್ ಕೊಡಿ ಅಂತ ನಾವು ಕೇಳಿದೀವಿ ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಕಾಂಪನ್ಸೇಷನ್.
ಆಯ್ತು 30ನೇ ತಾರೀಕು.
30
ತಾರೀಕು.
20 ಮೈ ರಿಕ್ವೆಸ್ಟ್ 27. ಅವ್ರು ಅವತ್ತಿಂದ ಹೇಳ್ತಲೇ ಇದ್ದಾರೆ.
ಆಯ್ತು 30ನೇ ತಾರೀಕು ಏನಾಗತ್ತೆ?
Serial number 47, madam.
Serial number 40, man.
50. 39, anybody adjournment? 40?
40.
Yes.
Appearing for the petitioners, your lordship. May I kindly have it on 22nd? Because what we have been informed is that.
Once more time, I say.
No, he sent the documents for signatures, your lordship. He'll file. This is what we got information from the other side.
39.
No, lordship, it will be two.
29th ಇರ್ಲಿ ಬಿಡಿ, ಏನಾಗಲ್ಲ, 29.
Interim order may be extended. your
ಆಯ್ತು, interim order extend ಮಾಡಿ.
lordship. Obliged.
41.
41 ನಿಮ್ದು.
And only I received the objection from R7 and R8.
Who are you? The request of petitioner, call on. 49. Yes.
47, madam. Serial number 47, may I request for next week?
Parted matters.
Parted, madam.
ಸಂಕೇತ್ ಎಮ್ಮಿನಿಗಿ.
He has completed the argument. We have-
ಸಂಕೇತ್ ಎಮ್ಮಿನಿಗಿ ಸರ್.
And
Wait, please, your lordships. Sanket, they want some time.
next week,
Next week ಯಾವಾಗ?
any day, 27, 28.
28. See, ಅದ್ರಲ್ಲಿ ಮೇನ್ ಆಗಿ ಮಾಜರು
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ. They have to produce.
ಅಲ್ಲಲ್ಲ, ಅದು
ಮೇಲೊಂದು
ಟೇಕಿಂಗ್ ಪೊಸಿಷನ್ ಒಂದಿದೆ, ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ಸೈನ್ ಮಾಡಿರೋದು ಇನ್ನೊಂದಿದೆ.
2 different dates.
You have to prove that.
Not only that, my lord. The division bench has considered all these aspects in the matter.
That's, I want.
Because I was also witnessing when the hearing was going on. It is a similar case.
Two judgments.
Okay.
Your
50.
lordship, serial number 41, I have a.
Interim order may kindly be extended, my lord, in 47.
47 ಅಲ್ಲಿ
41.
ಒಂದ್ ನಿಮಿಷ ರೀ, 47 ಅಲ್ಲಿ ಇಂಟರ್ ಮಾಡೋದು ಎಕ್ಸ್ಟೆಂಡೆಡ್. 41 ಯಾವಾಗ ಬೇಕಪ್ಪ?
41.
Fourth, I have a personal difficulty.
ಒಂದ್ ನಿಮಿಷ.
I have a personal difficulty. Fifth or a later date.
When do you want? 5th ಆಗತ್ತೇನಪ್ಪ?
Fifth is okay.
Serial number?
41.
41, 5th ಗೆ ಹಾಕಿ.
59.
Serial number 52, your lordship.
28.
Serial number 52, kindly have it 28, your lordship.
You for?
Petitioner,
Right, 28 ಕೊಡು.
28.
Next adjournment.
Sir.
So court officer. Sir. Sir.
No, you can.
Court officer. Court officer,
It's in Bada. Fast one, my friend. 18, list one.
List 2, serial number 17, needed an adjournment, my lords. The respondent also has called us and informed their not.
ಹೇಳಿದಿರಾ ಅದರ್ ಸೈಡ್ಗೆ?
ಹಾ ಹೇಳಿ, ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ. Serial number 17.
18 ಮ್ಯಾಟ್ರಪ್ಪ, ಬೇಗ ಮುಗಿಸ್ಬಿಡಿ. ಯಾವತ್ತು ಬೇಕು?
ಎನಿ ಟೈಮ್ ಫಸ್ಟ್ ವೀಕ್, my lords.
ಫಸ್ಟ್ ವೀಕ್ ಒಂದು ಡೇಟ್ ಕೊಟ್ರಿ ಅವರು. ಸೀರಿಯಲ್ ನಂಬರ್ 17
ಹಾ, ಲಿಸ್ಟ್ 2, my lords.
17, 28.
28 ಕೊಡಿ.
serial numbers.
Serial number 2, my lord.
ಹಾ.
Kindly grant 1 week time. And Proceedings Council, the regular council is not.
Number
2, my lord. List number 2, serial number 2.
The request of petitioner.
Yes. I'm appear by petitioner to take steps to person number 2, my lord.
Call up to 2 weeks.
Public.
Compliance by that.
Serial number 16, my lord. I have informed the other side there's some inconvenience today, my lord. If it may be taken up on 27th or 28th, my lord.
For the petition, serial number 16, Your Honor.
R1 to R4 time back.
Please,
Yeah.
please, my lord.
Will be granted, Your Honor.
The request of respondent number 1 to 4 call on ಯಾವ್ದು ಬೇಕು ನಿಮ್ಗೆ?
28th, my lord. 27th or 28th, my lord.
28.
Grateful, my lord.
Yes, call pass-over matters.
Pass-over matters. List one, 18, Roy Swami,
Petitioner, my lord.
Siddharth HM.
Lord, this case is concerned, my lord. The final notification issued in the year of 2001, my lord. 15/9/15/797 is my lord. Lordship say that I will take instruction on that point, my lord.
Okay,
Final notification ಆಗಿದೆ ಅಂತೆ.
Council.
Yes, my lords.
Additional AGS says final notification has been issued. Probably you need to challenge it.
In respect of my lord, and whether the survey number is included or not, others note, but for respond number ಹೇಳಬೇಕು.
My lords, at annexure C, at annexure C, my lords, we have asked for the entire proceedings of acquisition proceedings, but they have only said that there are 2 notifications which are issued and that is preliminary. And further,
I'll
they've said,
direct them, I'll do one thing. I'll direct them to make the submission by, I'll grant them 3 days time.
yes, please, my lords.
Yes, respondent number, serial number is
18, sir. First list.
respondent number 2 is directed to verify and state whether final notification has been issued in respect of the lands of the petitioner by next date of hearing. Call on, 3 ದಿವಸ ಬಿಟ್ಟು date ಕೊಡಿ.
22nd.
22nd.
Much obliged.
Yes.
Number 28, list 1, serial number 28 in list 1. Pass over, madam.
Respondent number 1, my lord.
Vishalappa, Shilpa Shah, Joshi, S.R. Joshi.
Yes, none appears with the petitioner. Dismissed for non-prosecution.
Obliged.
Parkola Kottala, none appears with the petitioner. Even when none appears with the petitioner, even when the matter is called out second time today. The writ petition is of the year 2018. It appears petitioner is not interested in prosecuting the writ petition. Writ petition dismissed for non-prosecution. Yes.
39. Sir, Siddharth.
Siddharth.
In that matter, my lords, my instructions are, my lords, that the matters have been re-entrusted to another colleague.
Which advocate?
My
Whose
lords,
name has to be shown? Tell me.
My lords, they have not intimated me. I just received a letter.
Ask them, can't you verify whether
tried to
final
do that.
notification has been issued or not?
Multiple times I have tried to do that, my lord. In this present situation, my lords, what has happened is they are not even ready to tell me anything. The entire, the practical situation is that all the files are taken over by the commission. They don't want to tell anything. That's become a problem.
Okay, can you communicate to them? I have adjourned it by 3 days, 22nd.
Yes, sir.
If concerned advocate does not come and report, heavy cost will be imposed on.
I will definitely intimate them, my lords.
Yes,
And I'll
sure.
also instruct them, to the alternate advocate whoever is there, let them come and.
Yeah.
Yes, ma'am. So I'll just intimate them.
Yeah, sure.
Not 3 days, my lords, if my lords may adjourn it for a week or so.
I said 22nd, let there be some pressure, I say. Let them do it.
Fine.
ಇವತ್ತೆ ಮೇಲ್ ಕಳಿಸ್ತಿರೋ ಲೆಟರ್ ಕಳಿಸ್ತಿರೋ ಫೋನ್ ಅಲ್ಲಿ ಮೆಸೇಜ್ ಆಗ್ತಿರೋ ಏನೋ ಒಟ್ನಲ್ಲಿ
I'll do that.
let there be something in writing. Tomorrow they should not hold you.
Definitely, definitely.
That's it. Yes.
Thank you, sir. Obliged, ma'am.
39. List 1, 39.
30 ಏನಾಯ್ತ್ರಿ?
Sir?
30 ಅರ್ಜನ್ ಆಯ್ತಾ?
30. 29 8 ಆಯ್ತು sir.
ಹೌದಾ?
Narayan Bhatt is ruling.
ಕರೆಕ್ಟ್.
39. Jeevan Kumar BS. Jeevan Kumar BS. The last time AGA time.
My lord, in this case, my lord, want to file a statement of objection regarding, my lord, acquisition for the, my lord, central jail, my lord, Korapanagra is concerned.
Anyone?
Or 2 weeks time.
The request to respondents call on 2 weeks bit date ಕೊಡಿ.
39. Number 40, 41 adjourn. 42, Rakshit R. Rakshit R. HL Pradeep Kumar.
I appear for the petitioners, my lord, in this matter. Lord petitioner, my lord, is a common petitioner in serial number 42, 43, 44. Lord, the petitioner intended to purchase certain lands, my lord, in and around the other side is not present.
Where is Pradeep Kumar?
Pradeep Kumar.
42.
42.
Kindly have it, sir, next week, my lord.
Go ahead, madam. The request of respondents. Call on date ಕೊಡಿ next week.
29.
ಮೂರು 43, 44 ಅಷ್ಟ. 42, 43, 44.
46, 47 adjourn. 48 adjourn. 49. MS Varadarajan. MS Varadarajan HL Pradeep Kumar.
Kindly pass over this matter, my lord.
Pass over.
50, Padubidri Mohan, Ashok N Nayak, serial number 50.
ಇದು dismiss for non-prosecution ಮಾಡಿ ಅದು ಮೇಲೆ ಹೇಳದ್ನಲ್ಲ ಆ ರೀತಿ only thing is this writ petition is of the year 2015. ಇದು ಈ ರೀತಿ ಮಾಡಿ none appears for the petitioner even on the last date of occasion none appeared for the petitioner. The writ petition is of the year 2015. It appears petitioners are not interested in prosecuting the writ petition dismissed for non-prosecution. Yes.
51, Ashok N Nayak, YSH Reddy.
ನಾನು ಹೇಳೋದು ಗೊತ್ತಾಗ್ತಿಲ್ಲ ಅಂದ್ರೆ ಕೇಳಿ. Okay.
51.
What is this matter, sir?
Lord, they have filed an application, you know, 152, seeking for amendment, my lord, in the decree which was passed in 2008. 2014, my lord, they filed an application after losing in MFA. Reference court, my lord, has modified the order. MFA was filed. MFA was dismissed. Thereafter, my lord, to come over the order of the, which they could not achieve directly. Now they filed an application, my lord, under 152 CPC. That application, my lord, came to be rejected by the trial, against which writ petition. In fact, section 47, my lord, CPC, executing court can go into the, all the aspects, my lord, relating to the execution. Formal objections, my lord, it is ready. File it, my lord, in the.
Yes, none appear for the petitioner. Call on next week date could you?
30, 30.
ಇವರಿಬ್ರು ಬಂದ್ರಲ್ಲ ವರದರಾಜನ್ ಪ್ರದೀಪ್ ಕುಮಾರ್ ಸರಿ ಕೇಸ್ ತಗೊಳ್ಳಿ.
49. 38, 51, 38. 49, sir.
ಹೇಳಿ ಸರ್.
HL Pradeep Kumar.
Ready, Pradeep?
And acquisition proceedings initiated under the Land Acquisition Act. That is challenged. Three grounds had been urged in the writ petition in support of.
What do you want?
That's the first one. The first one was, of course, now it is covered against me by the Supreme Court judgment. I had taken that ground that the division bench of this court had said, in the absence of formulation of any scheme, the land acquisition proceedings are bad. But that it appears the Supreme Court has reversed that and then said there is no bar for initiating the land acquisition proceedings and all that. Now, the two other points which I have urged in the writ petition is that between the preliminary notification and the final notification, more than 1 year has elapsed. That is in violation of the statutory provision. More important ground is that's after the final declaration was issued. That's within 2 years, the award was not passed.
The award passes.
I will give the dates. That's the.
Award was passed on Lord 33/2011.
Preliminary notification ಯಾವಾಗ?
Preliminary notification law dated 19/9/2006.
Final?
Lord, final notification
2/2008.
29.
2008.
2/2008.
28/2/2008
ಹೌದು.
Award?
Award 33/2011.
How do you overcome this?
Lord, kindly take note.
Synopsis.
Synopsis, Lord, short synopsis. Lord, kindly take Lord my synopsis.
One ನಿಮಿಷ. First provision ಓದಿ.
Provision, Land Acquisition Act 1894, Lords.
11
11A.
11A. Period within which an award shall be made. The collector shall make an award under section 11 within a period of 2 years from the date of the publication declaration, and if no award is made within that period, the entire proceedings for the acquisition of the land shall lapse. provided that in case where said declaration has been published before the commencement of the so and so, ಅದೇ relevant. ಅದೇನ್ ಬೇಕಾಗಿಲ್ಲ. ಈಗ within 2 years ಅಂತ ಇದೆ ಸರ್. You'll ask me kindly take my synopsis.
Court in the state,
ಅಲ್ಲ, ನಾನು I'll just explain. Lord, preliminary notification was published on 19/9/2000. ಎರಡನೇದು. Preliminary notification was gazetted on 12/10/2006. Preliminary notification, my lord, was lastly, my lord, published in the notification Gram Chavdi, my lord, 3/2/2007. From here, my lord, inquiry was held under 5A and final notification, my lord, was issued on 2/2/2008. Preliminary final notification 2/2/2008. Published in Gazette on 28/2/2008. Lord, last publication, my lord, is relevant, my lord, for the purpose of, my lord, passing award. 29/4/2009, my lord, is the last publication of, my lord, the final notification. My lord, and the award is passed on 33/2011. That is well within, my lord, 2 years as, my lord, stipulated, my lord, in the 11A of, my lord, the Land Acquisition Act.
Is it so?
It's within, my lord, time. ಅದಾದ್ಮೇಲೆ 16/2 ಆಯ್ತು ಸ್ವಾಮಿ. 31/12/2004. Thereafter, after 2 years, my lord, after taking possession under 16/2, my lord, the writ petition came to be filed, my lord, in the year 2014. That is after lapse of, my lord, 2 years. By that time, my lord, possession was already taken and, my lord, developmental activities, my lord, were.
Gain development.
Road ಅದು ಲೇಔಟ್ ಇದೆ, ರೆಸಿಡೆನ್ಷಿಯಲ್ ಲೇಔಟ್, ಹೌಸಿಂಗ್ ಬೋರ್ಡ್.
Photos ಇದೆಯಾ?
ಫೋಟೋಸ್ ಲೇಔಟ್ ಮ್ಯಾಪ್ ಇದೆ.
Map is different.
Last date of publication, my lord, is relevant, my lord, for the purpose of, my lord, passing award of the, I am, lord, I have submitted list of citation, lord, the last date of hearing. Last me kindly take.
See, what the act says is, within a period of 2 years from the date of publication of the declaration.
Lord, the division bench of this honorable court and Supreme Court has, my lord, categorically added that, my lord, the last date of publication of, my lord, the notification on 6/1 is relevant for the purpose of, my lord, passing award. Supreme Court has also held, my lord, in many cases.
See, what is relevant is date of the publication of the declaration.
Even publication under, my lord, I got it.
Now listen, so with, in reference to case laws, show me that,
ಅಲ್ಲ, ಈಗ ನಾನೊಂದು ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿನಿ, ಇವ್ರೆ ಕೋರ್ಟ್ ಆಫೀಸ್ ಲಿಸ್ಟ್ ಆಫ್ ಜಜ್ಮೆಂಟ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ದು ಫೈಲಲ್ಲಿ ಇದೆ. Last page number 112, my lords.
ಅಷ್ಟೇ ತಾನೆ ಸರ್ ನಿಮ್ ಕೇಸು?
2/2/2008.
Narrow compass, the only ground is award is belated.
ಹೌದು. ಬಟ್ ಅವರು ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ
That is the ground.
ಕೊಟ್ಟಿದ್ರೆ
Sir, the only ground is award is belated, right? Nothing else. That is the only ground.
that's the only ground that
Yes.
now survives.
Lord, page number 152 is relevant, my lord. The judgment start from page number 112. The division bench.
152.
152 is, my lord, relevant, my lord. Lord, ಅದಕ್ಕಿಂತ ಮುಂಚೆ 148 ಓದ್ಬೇಕು. ಪೇಜ್ ನಂಬರ್ 148, ಇಂಟರ್ನಲ್ ಪೇಜ್ ನಂಬರ್ 37. ಅದರಲ್ಲೂ ಸೇಮ್ ಸಿಮಿಲರ್ ಸಿಚುಯೇಷನ್. 147 ಇಂದ ಶುರು ಆಗುತ್ತೆ ಆಕ್ಚುಲಿ. 148 is 147 ಅಂದ್ರೆ ಪ್ಯಾರಾ 23, 147 ಪೇಜ್ ನಂಬರ್. ಪ್ಯಾರಾ 20.
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ರ ಜಜ್ಮೆಂಟ್?
ಕೊಟ್ಟಿದ್ದೀವಿ ಸರ್, ಬಹಳ ದಿನ. 147, my lord, page number 36, internal page number, para 23, my lord. For the better understanding of the aforesaid portion, it would be useful for the tablet for publication made in the instant case. Same, my lord. Preliminary notification gazetted on 22/4. My lord, it was published in newspaper. That is also one of the mode of, my lord, the publication notification. Then, my lord, Mazar was drawn village Chavdi. My lord, column number 6, seal number 6, published on the village Chavdi. 24/5/2011. Thereafter declaration. Declaration is gazetted on, my lord, 26/4/2012. There also, my lord, award was not within, my lord, 2 years from the date of publication of the notification, gazette notification. Then this first question, my lord, arose. On reading of the above, it is evident that the declaration and final notification of 6(1) of the Act is shown within 1 year from the last date of publication, and the village shall be published on 24/5/2000. Therefore, there has been compliance of the said provision in subsection 1 of section 6 of the 1894 Act in instant case. Hence, the equation is not at all vitiated. In the context, it would be useful and refer to the following observation of Honorable Supreme Court and so on. So, next, my lord, that is not relevant. Page 50. that
ಇವ್ರು
is
ಅವಾರ್ಡ್
also-
ತಗೊಂಡಿದಾರ ಇಲ್ವಾ?
ಹಾ?
ಅವಾರ್ಡ್ ತಗೊಂಡ್ರ ಇಲ್ವಾ ಇವರು?
ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀವಿ ಕೋರ್ಟಲ್ಲಿ, ಅವ್ರು ತಗೊಳ್ಳಿ.
ಇಲ್ಲ ಅವಾರ್ಡ್ ತಗೊಂಡಿಲ್ಲ ನಾನು.
ಕೋರ್ಟಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. Thereafter 54, my lord, page 54, 154. At this stage, it is necessary to consider the submission made by the so and so. Let petition remand the matter. Adadmele next. Same. Last date of publication is, my lord, relevant, my lord, for the purpose of, my lord, calculating, my lord, the period. Not, my lord, the date of gazette.
ಎಲ್ಲಿದೆ ಓದಿ ಅದು?
ಅದು ಈಗ 148 ಅಲ್ಲಿ ಓದಿದ್ನಲ್ಲ ಸ್ವಾಮಿ, ಬರಲ್ಲ. 152, 150, ಅಲ್ಲ. 152. The same would also indicate that the object and purpose of the amendment is to ensure that between the last date of publication of notification and giving such public notice, namely village Shavdi publication and publication in the official gazette under subsection 1 of section 6, there cannot be lapse of more than 1 year.
That's between preliminary and final notification.
6(1) ಗೆ village Shavdi ಇದು. Page number 152 ಅಲ್ಲಿ, last para. Raghuveer Dayal case ಅನ್ನ refer ಮಾಡಿ.
No. Show me a case law which says when we say date of publication under section 11, it is not gazette notification,
ಅಲ್ಲ,
but it is village Chavdi. ಅದನ್ನ ತೋರ್ಸು.
ಇದೆ. ಇದರಲ್ಲಿ ಮಾಡಿ, ಇದರಲ್ಲಿ ಕ್ಲಿಯರ್ ಕಟ್ ಆಗಿ ಬರುದಿದೆ. Lord,
Yeah,
page
4161.
page number 145. Lord.
ಈಗ 4161 ಒಂದ್ ವರ್ಷದ ಅವಧಿಯಲ್ಲಿ ಆಗ್ಬೇಕಲ್ವೇನಪ್ಪ?
Lord, 4(1) ಅಲ್ಲೂ ಅಷ್ಟೇ. The date of, my lord, the lastly published, my lord, in the village Shavdi, my lord, is, my lord, the everywhere, my lord, in the after issuance of 4(1), my lord, after gazette, my lord, it will be issued, my lord, in newspaper. Thereafter, my lord, village Shavdi. Village Shavdi date, my lord, has to be taken into consideration for, my lord, 6(1) notification, calculation of, my lord, 145 para 20. All three forms of publications are equally mandatory. There is no particular basis that gazette publication or publication in the newspaper or the publication in the locality must follow a particular order. All three publications are provided by law and stands on the same footing.
ಎಲ್ಲಿದೆ?
Page number 145. Para 20, my lords. Page 145. Para 20. All three forms of publication, that is, my lord, village Shavdi, newspaper and gazette. First, my lord, gazette, thereafter, my lord, newspaper, thereafter, my lord, village Shavdi.
ಎಲ್ಲ all three forms of publication ಎಲ್ಲಿದೆ ಅದು?
Page 145 ಅಲ್ಲಿ, para 20 ಅಲ್ಲಿ ಶುರು ಆಗುತ್ತೆ ಸರ್. All three publications provided by law and stands on the same footing. The gazette has no statutory basis and its publication is merely on the official act of the government. The sanctity which attaches to publication of notification in sections 4 in official gazette attaches equally to two other forms of publication. There is no reason to prefer one over other, nor would it be right to say that one form of publication is more important or one form are more fundamental than other. What is necessary is the continuity of action and should not appear to be broken by gap of time so large as may lead one of the prima facie conclusion of lack of bona fide and acquisition. The publication of the substantive notification in the locality can be made within a reasonable time after the publication of the Gazette, and what is reasonable time depends on the facts and circumstances of each case. It cannot be said that delay in publishing the substance of notification would per se vitiate the acquisition proceedings. In other words, there should be a continuity of the action in the publication of Gazette notification in the newspaper and also giving public notice. That is village Chavadi, my lord. The time factor is
Para 17 in the Odisal. Paragraph 17, adjustment.
last date of publication. One lesson. We thus find that the expression, the last date of such publication and giving such public notice being thereafter referred to as the date of publication of the notification inserted in subsection 1 of section 4 of the 1894 Act with effect from 24/9/1984 by Act 68 of 1984 must be read in consonance with the second proviso to subsection 1 of section 6 of 1894 Act, which has not been done so by the learned single judge. The learned single judge has, on the other hand, proceeded to hold that in the instant case, the village Chavdi publication itself being published behind the period of 1 year from the date of publication notification in the newspaper, and hence there was non-compliance of proviso 6, subsection 1 to section 6 of 1894. This is not that. We find that such a position is not envisaged under the 1894 Act in as much as there is no time frame within which the official gazette notification, newspaper publication, and village Chavdi publication has to be made. The time frame of 1 year is from the date of from the last date of publication and date of notice under section 4(1) of the 1894 Act and the date of publication of declaration and final notification, which should not exceed 1 year. Hence, we find that the last single judge did not take into consideration the amendment made to subsection 1 of section 4 and 1894 Act in juxtaposition to a second proviso to subsection 1 of section 6 of 1894. Therefore, the conclusion reached by the learned single judge that there was a lapse of more than 1 year from the date of publication in the newspaper and the date of Chavdi publication. Therefore, the acquisition was vitiated in, view of, in our view is not correct. Therefore, the aforesaid position has been clarified by the amendment being made to section 4(1) of the Act by the Karnataka amendment by incorporating the expression the last date of such publication and giving such public notice being the hereinafter referred to as the date of publication.
So 4(1), no, pause for a minute and read 4(1).
4(1), my lords.
Directly.
Please. Lord, preliminary publication, preliminary notification, powers and officer thereon. Whenever it appears to the appropriate government or the deputy commissioner that the land in any locality is needed or likely to be needed for any public purpose or for a company, a notification stating that the purposes for which the land is needed or is likely to be needed and describing the land by survey number, if any, and its approximate area shall be published in the official gazette and in 2 daily newspapers circulating in a locality of which at least one shall be in the regional language, and the deputy commissioner shall cast public notice of the substance of such notification be given at a convenient places in the said locality. The last date of such publication and giving such public notice being hereinafter referred to as the date of publication of the notification. The deputy commissioner may also cause a copy of such notification to be served on the owner or where the owner is not the occupier and the occupier of the land. The last date of publication.
The language here is not similar to the language in 6(1).
But, my lord, the Vigian bench specifically, my lord, takes, my lord, the amendment made to, my lord, 4(1) and, my lord, says that last date of publication, which is amended, my lord, in 4(1) has to be taken.
No. See, 4(1)(6)(1), language is different, and in this judgment that you are citing,
please.
Last date of publication as per 4(1) is examined. Last date of publication as per 6(1) is not examined.
No, my lord.
See, the word used in 4(1), Pradeep, is last date of publication. See, that's where things becomes important. Intention of the legislature. See, whenever it appears to the appropriate government that the land in any locality is needed or likely to be needed for any public purpose, describing the land by its survey number, if any, and its approximate area shall be published in the official gazette.
Yes.
And in 2 daily newspapers circulating in that locality, of which at least one shall be in the regional language, and the deputy commissioner shall cause public notice of the substance of such notification to be given at convenient places in the said locality. So here, three types of publications are compulsorily envisaged.
Yes, ma'am.
One is in the official gazette,
Newspaper
ಇನ್ನೊಂದು it is
Newspaper.
newspaper,
and ಇನ್ನೊಂದು
ಇನ್ನೊಂದು
Chavdi, village Chavdi.
village chavdi, or a
Locality.
place where the property is existing. You can take it as village chavdi over here,
Yes, ma'am.
okay, or it has to be served on the land.
Yes.
And he may serve the
Owner or occupier
owner
of the
of
land.
the occupier of the land,
Correct.
okay. So publication as per 4(1) includes all the three modes of service.
Correct.
And it does not contemplate that all the three modes of service have to be done at one go.
Yes.
And there is no time frame fixed.
Contemporaneous, my lord, the service, my lord, the
And
mode of
there is
publication
no time frame fixed. It should
Correct.
be reasonable time,
within a period of 1 year gap. That
not 1 year. It
That
should
is
be
reasonable.
within reasonable time.
that
Okay.
same my lord astic.
Listen, come to 6(1). That's why I told you.
Lord, ಅದನ್ನ 6(1) para 17 ಅಲ್ಲಿ clarify ಮಾಡಿದ್ದಾರೆ ಈಗ judgment ಓದಿದ್ರು.
Fine, we'll read that.
Please,
But before that, come to 6(1).
please, my lord. Declaration that land is required for the public purpose.
Ah.
Subject to the provisions of part 7 of the act, when the appropriate government is satisfied after considering the report, if any, made under section 5A subsection 2, that any particular land is needed for public purpose or for company, a declaration shall be made that effect under the signature of the secretary to the state, such government or of such officer duly authorized to certify its orders. And different declaration may be made from the time to time respect of different parcels of land covered by the such same notification as under section 4 and subsection 1, irrespective of whether one report of the different reports has or have been made wherever required under subsection 5A, so on. So next, provided that no declaration in respect of any particular land covered by the notification subsection 4 published after the, that is not relevant.
Two bane, clause 2, that may be relevant. That may help your cause.
Yes, ma'am.
Every declaration shall be published in the official
Yes.
gazette.
Yep.
The official gazette.
Every declaration shall be published in the official
Two
gazette and in the
newspapers.
2 daily newspapers circulating the locality which the land is situated, of which at least one of shall be the regional language, and deputy commissioner shall cause public notice of the substance of such declaration to be given convenient
It's
places.
a
in the
replica.
locality. The
It's
last date,
it's a replica of 4(1).
the last date of dates of such publication, giving such public notice being referred to as the date of publication. Idaralla sir.
No. It's a replica of 4(1).
4(1), same.
Same. Okay.
So my lord, the
Now
last
come
date,
to, now come to 11.
11,
Now come to 11.
11 AM, 11.
11A. Yeah.
Period within which an award shall be made.
Hmm.
The collector shall make an award under section 11 within a period of 2 years from the date of publication ಅಂತ ಹೇಳ್ತಾರೆ ಅದ್ರಲ್ಲಿ.
So publication, here also it envisages
Declaration.
three
and
types
different-
of publication. Must and
Publication.
should.
Publication means my lord 3 modes.
Three
The
types of-
last mode of publication is relevant my lord for
is
calculating. the award.
relevant for
So
calculation.
my lord, as per my lord, the award which was passed on 33/2011, my lord, well within the period of 2 years from the date of my lord, the last date.
Now
of-
come to the judgment.
Please. Parallel 17, my lord, page number 142.
Ode.
We thus find that the expression, the last dates of such publication and giving such public notice being hereinafter referred to as the date of publication of the notification inserted in subsection 1 of section 4 of 1894 Act with effect from so and so by Act number so and so may be read in consonance with the
This is important.
second provision, same
What we read right
replica.
now.
6(1), and which has not been done so by the learned single judge. The learned single judge has, on the other hand, proceeded to hold that the instant case that the village Chavdi locality publication itself being the published behind the period of 1 year from the date of publication of the notification in the newspaper, hence there was no complaints of the provision of subsection 1 of section 6 of 1894. We find that such a position is not envisaged in 1894 Act, in as much as there is no time frame within which an official gazette newspaper publication CH-18 has to be made. The time frame of 1 year is 1 year is from the date of last date of publication of and date of public notice under 4(1) 1894 Act, and the date of publication declaration final notification which should not exceed 1 year. Hence, we find that the learned single judge did not take into consideration of the amendment made to subsection 1 of section 4 of 1894 Act in the so and so to the second proviso to subsection 1 of section 6 of the Act. Therefore, the conclusion reached by the learned single judge that there was a lapse of more than 1 year from the date of publication of newspaper of the date of the Chavdi publication, the acquisition initiates is not in a correct law, correct. This squarely covers, my lord, the balance.
1920 follows.
Yes. Yeah. In Raghubil Ral, my lord, Dayal case also, my lord, similar case, my lord, Supreme Court, my lord, has taken same view, my lord. Page number 153. Internal page.
Yes, sir. How do you overcome this judgment?
As far as the judgment is concerned between section 4 and section 6 notifications. Between section 6 and 11A, 2 years time. But there the award is passed beyond 2 years. From the date of the final declaration.
See, final declaration has to be done in 3 modes, sir. Final declaration has to be done in 3 ways. Okay. 15, ನೀವು 6 clause 2 ಓದಿ.
Same amendment has to be carried.
3 ways ಅಂದ್ರೇನು? ಒಂದು ಗೆಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ ಆಗ್ಬೇಕು. ಎರಡನೇದು ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಆಗ್ಬೇಕು. ಮೂರನೇದು
ವಿಲೇಜ್
ಲೊಕ್ಯಾಲಿಟಿ ಪಬ್ಲಿಕೇಶನ್ ಆಗ್ಬೇಕು. Okay, all the 3 publications are mandatory. That is what is contemplated in so far as it relates to section 4 also. And this judgment, while analyzing the same, has come to the conclusion they need not be together. All the 3 need not happen at the same time.
Or in the same order.
Or in the same order. It needs to be done within a reasonable time. That's all. And what is reasonable depends on facts and circumstances of each case.
Yes. And whichever is the last should be taken into consideration.
Whichever is the last, that has to be taken into consideration. As per the objections filed by KADV, KHV, 29/4/2009 is the last publication. So if we take from 29/4/2009, award is passed on 33/2011.
Within 2 years.
And date of declaration of general award is 28/4/2011. Just 1 day before completion of 2 years. They are within time, sir. What do you do?
Lord, you can opt for, Lord, 50-50 land sharing. My Lord, I agree.
Sir, they are willing to offer you 50-50 land share. I think that's a fantastic proposal.
They are giving?
They don't mind offering you 50-50 land share. I'll make that observation and dispose it off if you want.
200 meters within the Gram Tana limits anta one ground. That may not, I understand. That is one of the grounds urged in the writ petition by my.
I'll record his statement, 50-50%. Huh?
He doesn't want, my Lord, that is the best offer, my Lord, what we can. Even it is more than complete.
Sir, any day it's a fantastic offer, sir, under the circumstance. Madbodalva? Will pass orders.
It will be a court order.
It will be a court order.
Very good.
Yes, Bunny. Agreed by the acquisition of his lands measuring 6 guntas in survey number 103/6 ಗೊತ್ತಾಗ್ದಲ್ಲ ಇದ್ರೆ ಕೇಳಿ ಮೇಡಮ್. ಇನ್ನ ಕನ್ಫ್ಯೂಷನ್ ಅಂದ್ರೆ you can go back to recording. This is recorded. So you can just agreed by acquisition of his lands measuring 6 guntas in survey number 103/6, comma 1 acre 14 guntas in survey number 100/3 and 25 guntas in survey number 65/1 of Adigondanahalli village, Attibile Hobli, Anekal Taluk, for the purposes of second respondent Karnataka Housing Board, the petitioner has preferred this writ petition. Full stop. Next paragraph. Though several grounds are urged in the writ petition, in the course of the arguments, the learned counsel for the petitioner submitted that he relies only on the ground that the award passed subsequent to the award has been passed belatedly in the instant case and contents that there is lapse of more than 2 years since the date of there is a lapse of more than 2 years
Issuance of.
between the date of declaration under section 6(1) of Karnataka 6 clause 1, clause 1 of
Land acquisition.
the Land Acquisition Act, Karnataka law, the Land Acquisition Act 1894, and the award passed under section 11A of the Act, 11 capital A of the Act. Full stop. Next para. Per contra, the respondent submits that the said that the award has been passed within a period of 2 years as contemplated in law and prays for dismissal of the writ petition. Full stop. Next para. The question that arises for consideration is whether there has been a lapse of more than 2 years between the final declaration issued under section 6(1) of the Land Acquisition Act and the award passed under section 11A of the Act or not. Full stop. To next para. To determine the aforementioned question, it is essential to verify the dates of the relevant dates under which the final declaration has been published and the award has been passed. Full stop. Next para. Section
4 subsection.
4 section.
4 Akbar.
6 in the.
ಅದು ಎರಡರಲ್ಲೂ 6. 6 subclass, so 2 minutes.
6 steps plus 2 and 1 and 2.
Section 6, section 6 bada. After issuance of preliminary notification under section 4 clause 1 of
Land acquisition.
the Act of the Act, a final notification will be issued if the authority concerned is of the opinion that the land is required to be acquired under section 6(1) of the Act. Full stop. The said declaration requires to be published as contemplated in section 6 clause 2 of the act, which reads as under. Six two ಮಾತ್ರ ಇದು extract ಮಾಡಿ ಇಲ್ಲಿದ್ದಾರೆ ಇಷ್ಟು ಮಾತ್ರ ಅಷ್ಟೇ. Next para. The aforementioned provision which contemplates publication of the final notification is paramateria with section 4 clause.
One. Oh, one. Or one ಅಲ್ಲೇ ಇದೆ.
4(1) of the act which requires insofar as it relates to publication of preliminary notification is concerned. Full stop. Section 4(1) of the act reads as under. Full stop. Next para. Thus, both section 4(1) and 6(1) of the Land Acquisition Act requires the notifications to be published in 2 daily newspapers circulating in the locality, of which at least one shall be in the regional language, publication in the official gazette, and the same being displayed at convenient places in the said locality, which usually will be on the land as well as the village chowdi. On the land as well as the village chowdi. Full stop. The act does not contemplate that all the 3 types of publications have to be done simultaneously or in a particular order. Full stop. Under the said circumstances, all the 3 publications are required to be done within a reasonable period. Which depends. And the said reasonable period depends on case-to-case basis. Depends on case-to-case basis. Full stop. But under the circumstances, I am of the opinion that while calculating the time period between the final notification under section 6(1) of the act and the publication of the award
Passing of our. Passing.
passed under section 11 capital A of the act, the last date, the last date, the date on which the last of the 3 publications envisaged has to be
Taken.
considered. Full stop. In the incident case, the final notification was published on the relevant village Chavdi on 29/4/2009. Full stop. There is no dispute as to it. Full stop. The general award has been passed on
33.
30/3/2011. And there is a declaration of and there is and the declaration of general award is dated ಏನು declaration ಅಂದ್ರೆ
ಅದು ಗೆಜೆಟ್ ಅಲ್ಲಿ ಡಿಕ್ಲೇರ್ ಆಗ್ಬೇಕಾಗಿಲ್ಲ ಸರ್ ಪಾಸಿಂಗ್
ಹೊಡೆದಕ್ಕೆ asset ಅನ್ನು and ಇದನ್ನ the general award is passed on 33/2011 sir. Full stop. ಅದು ಬಂದಿದೆಯಲ್ಲ 11 ಅಷ್ಟೇ. Full stop. Full stop. The time period between the final date of publication the time period between the final date of publication of the final the final notification under section 6(1) and the passing of the award is therefore within 2 years. Within 2 years. Full stop. Under the said circumstances, the acquisition cannot be held bad due to lapse of time as contended by the petitioner. Full stop. Next para. At this juncture, the advocate for the petitioner submits that the petitioner would be satisfied if 50% of the developed land is granted to him as compensation in lieu of monetary compensation, as per the policy of
state, the government.
the Karnataka Housing Board / state. Full stop. Next para. The learned counsel for respondent number 2 submits
on instructions.
The respondent number 2 upon instructions submits that second respondent that if the petitioner were to make a representation to that effect, the same would be considered and appropriate decision would be passed. Full stop. Hence the following order. The acquisition of the lands of the petitioner, which is the subject matter of the writ petition, for the purpose of respondent number 2 is upheld. Full stop. Next para. Petitioner is given liberty to make a detailed representation to respond to make a representation to make a representation to the second respondent within a period of 4 weeks from today for grant of develop land in lieu of monetary compensation and respondent number 2 and 3. ಅದು ಮೇಲ್ಗಡೆನೂ 2 and 3 ಮಾಡಿ. ಅದು ಅಲ್ಲ ಇಲ್ಲಿ representation ಹೇಳಿದ್ನಲ್ಲ ಅದು respondent number 2 and 3 ಅಂತ ಹೇಳಿ. Respondent. And respondent number 2 and 3 shall consider the request of the petitioner in accordance with the policy of Karnataka Housing Board / state of Karnataka, and grant him developed land in lieu of monetary compensation. Full stop. Next para. Respondent number 2 and 3 are permitted to withdraw the amount deposited before the reference court pursuant to the general award, in the event petitioner is granted land in lieu of monetary compensation. Developed land in lieu of monetary compensation. Developed land in lieu of monetary compensation. Writ petition is disposed of accordingly. ಇದು ರಿಪೋರ್ಟ್ ಮಾಡ್ಬಿಡಿ ಇರ್ಲಿ. 6-1 explanation ಇಲ್ಲ ಅಲ್ವಾ?
ಇಲ್ಲ.
So report it.
Report ಮಾಡಿ.
On judge ಮಾಡೋದಂಗ.
103 survey number li 6 guntas ಇಲ್ಲ 3 guntas ಏನು 6 guntas is my ownership. What is notified is only 3 guntas.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಪಿಟಿಷನ್ ಶೆಡ್ಯೂಲ್ ಅಂತ ಹಾಕ್ಬಿಟ್ಟು ಯಾಕಂದ್ರೆ ಮಿಸ್ಮ್ಯಾಚ್ ಆದ್ರೆ ಮತ್ತೆ ಪ್ರಾಬ್ಲಮ್. ಅವ್ರಿಗೆ ಏನೋ ಕಡಿಮೆ ಬಂದಿದೆ ಅಂತ ಜಾಸ್ತಿ ಹಾಕಿದ್ದಾರೆ ಇದರಲ್ಲಿ.
ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಬರೀ 3 ಗುಂಟೆ ಕನ್ಫೈನ್ ಮಾಡಿದ್ರು ಅದೊಂದು ಸರ್ವೆ ನಂಬರ್.
ಬಿಟ್ಟಿದ್ದಾರೆ.
ವರ್ಷವಾಗಿ 6 guntas ಅಂತ ಬಂದಿದೆ. That should not lead to any confusion.
ಮೇಡಮ್ ಒಂದು ನಿಮಿಷ. ಇದು ಏನ್ ಬಂತ ಹೇಳಿ ಬಿಗಿನಿಂಗ್ ಅಲ್ಲಿ ಏನಂತ
103/6 6 guntas ಅಂತ ಬಂದಿದೆ. The final notification it was confined to 3 guntas.
ಹೇಳಿ. Measuring ಬೇಡ. Agreed by acquisition of his lands of certain lands belonging to him ಅಂತ ಶುರು ಮಾಡ್ಕೊಳ್ಳಿ. Agreed by certain lands belonging to him in survey number so and so. ಅಷ್ಟ ಮೆಜರಿಂಗ್ ಬೇಡ ಹೊಡೆದಾಕಿ. ಅವಾಗ ಸರಿ ಹೋಗೋದು ಅಲ್ವಾ?
ರಿಪೋರ್ಟ್ ಮಾಡ್ಬೋದು. ಇದು 6-1 ಮೇಲೆ ಯಾವ್ದು ಇಲ್ಲ, 4-1 ಮೇಲೆ ಇತ್ತು ಅದು. 6-1 ಮೇಲೆ
ಆಯ್ತು ಸಾಲ.
May I have liberty to Milord? Milord, serial number 28, Milord. My apology, I was not here. Milord, Milord, I appear for resolution number 2. I understand, Milord, it is dismissed for non-prosecution by petitioner. But Milord, I have filed one memo today with certain documents. So based on that, Milord, petition can be disposed of.
Madam, I passed my orders.
Yes,
It is dismissed for non-prosecution. If it is restored, then on that day you come and argue. Okay, yes.
Serial number 50.
DN.
50.
DNP. Writ of mandamus.
ನೀವು ಇರ್ಲಿಲ್ಲ DNP ಆಗಿದೆ.
Sorry, madam.
What type of submission is this? Ian, what is the matter? See, because you are not there, the other side went away.
Ashokan Nayak.
Show me how it is meritorious. Torse, why it should be entered. Put it serial number 50. ಏನ್ ನಿಮ್ದು ತಕರಾರ?
Next year G ಮೇಲೆ maybe consider madam.
Who are you, sir? How is your right affected? Are you the owner of the property?
I'm not a owner of
Then-
the property, my lordship. The remaining extent of land, my lordship, used by the villagers, my lordship, for the benefits of the Gomal land, my lordship, for
ಅಕ್ವೈರ್ ಮಾಡಬಾರ್ದು ಅಂತ ಎಲ್ಲಿದೆ? ಅಕ್ವೈರ್ ಮಾಡಬಾರ್ದಂತ ಕಾನೂನಲ್ಲಿ ಎಲ್ಲಿದೆ ಸರ್?
They already acquired, my lordship, remaining portion of the land, my lordship. They encroached by the, my lordship, others, allottees, my lordship. That's why, my lordship. Petitioners come. Earlier, annexure A, my lordship, they already approached by the petitioners, dishonorable court, my lordship. The dishonorable court directed the respondent number 213, my lordship, to survey the spot and give a report, my lordship. Till today, they are not made. Page number 16 is the operative portion of the order, annexure A, my lordship. Para number 7, my lordship.
ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ಅದು ಆರ್ಡರ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ, ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಆಗಿರೋದು. ಬಟ್ ದ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ಪಟಿಷನರ್ ಕಾಲ್ ಆನ್, ನಾಟ್ ಡೇಟ್ ಕೊಡಿ.
Please. 21st, please.
ಹೌದು ಬನ್ನಿ ಅಪ್ಪ. It's 2015 matters. You should not linger on like this. Yes.
53, serial number 53. Ramesh K R, Satish M Dodmani.
ಮೈಲಾಡ್ ಇದ್ರಲ್ಲಿ ನೇಮು HL ಪ್ರದೀಪ್ ಕುಮಾರ್ ಅವ್ರ ಹೆಸರು
Senior's name is shown, my lords. The party has got in touch with me. 3 days, my lords, I'll file my power.
You're for whom?
My lords, my senior's name, my lords, was.
No, you're for appear for
petitioner, my lords, petitioner.
The request to parties call on. Date told.
Monday, my lord, coming Monday, my lords. By then I'll file my wakalat.
ಯಾರಿದ್ದೀರಾ ಅವ್ರು ಬಂದು ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸ್ಬೇಕಾ?
ಪ್ರದೀಪ್ ಕುಮಾರ್ ಅವ್ರ ಹೆಸರು.
ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸ್ಬೇಕಾ? ಈ ರೀತಿ ಮಾಡಿ. Registry is directed to show the name of Shri H.L. Pradeep Kumar as the advocate appearing for respondent number 2 and 3.
That's my
Respondent
name.
number 2 in both the matters and in both the writ petitions. At the request of
Sagar BB.
Sagar B.
At the request of parties, call on. ಆಯ್ತು. And the name of Shri Sagar
BB, my lords. BB, my lord, double B.
BB as the advocate appearing for the petitioner. Full stop. At the request of parties, call on. Date ತಗೊಳ್ಳಿ.
Your lords, we'll have it next Monday, my lord. Next 27th, my lords. Next Monday is an non-sitting day.
27.
Obliged.
Second list, serial number 1. Second list 2, serial number 1. P. Sheshagiri Rao. This is for not
ನನ್ನ ಪೇಸೋದು ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿದ್ರಾ?
already dismissed for non
ಅದಾದ್ಮೇಲೆ ಬಂದಿರಾ? IML ಬಂದಿದ್ರಾ?
Yes, IML ಬಂದಿದೆ.
ನನ್ನ ಪೇಸೋದು the petitioner. Call on date ಕೊಡಿ 2 weeks ಬಿಟ್ಟು.
29. Serial number 2, SN Bhatt. Sir, serial number 2. Sir. ಅದು ಡಿಗ್ರಿ ಎಕ್ಸಿಕ್ಯೂಷನ್
One month. The present writ petition is filed challenging and issue warrant. Anticipate. Attachment of property. Attachment of property. The present writ petition is filed challenging issue of warrant for attachment of movable properties of JDR. Passed in execution number 1/1/2015 dated 26/4/2017 by so and so court. Full stop. Next para. None appears with the parties. ಯಾರಿಗೂ ಬಂದಿಲ್ಲಲ್ಲ ಈಗಿಲ್ವಲ್ಲ. None appears with the parties. Next para. The online case status reveals that the execution case has been disposed on 11/8/2023. Full stop. For that reason, next para. For that reason, for the aforementioned reason, the writ petition is dismissed as having become infructuous.
3. Sir, see number 3.
The writ petition is filed challenging the impugned order passed on IA number 12 in OS number 19 of 2014 by so and so court. By so and so court. Full stop. None appears with the parties. The same, online case status shows that the original suit itself has been decreed on 2/12/2022. Full stop. For the aforementioned reason, the writ petition is dismissed as having become infructuous.
4. See number 4.
ಇದು ಅಷ್ಟೇನಾ? ಇದು ಅದೇ ರೀತಿ ಇದು ಅಯ್ಯನಾ? NHLD ಏನಪ್ಪ ಇದು? In the instant writ petition, order dated 6/3/2017, passed in FDP number 5 of 2014 by so and so court, appointing a court commissioner has been challenged. The same reveals that it has been disposed on 8/7/23. Same accurate, dismissed as infructuous. ಗೊತ್ತಾಗತ್ತಲ್ಲ?
See number 5. List 2, Nagendra Kumar.
1 week time may be granted to, only there is in IM a lot, we have not mentioned the date of, that date has been mentioned, but delay, how many days delay has not been mentioned in the application, my lord. I'll next week or 10 days
The
time.
request of petitioner, call next week, need to by the.
Public.
6, government advocate.
Yes, Your Honor. Respondent number 2, Tahsildar, the memo of calculation ಕೇಳಿದ್ರು.
ಎಲ್ರಿಗೂ ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ?
Currently,
IA3 ಪೆಂಡಿಂಗ್ ಇದೆ ಅಲ್ಲ? ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ IA3 ಮೇಲೆ?
Yes, sir, notice.
ಅವರು ಮತ್ತೆ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. ಬರಲೇ ಇಲ್ಲ ತಹಸೀಲ್ದಾರ್.
issue notice on IA 1, 2, and 3 of 2023
So notice twice.
to the proposed legal representatives of deceased respondent number 1. Notice ಆಗಿಲ್ವಾ ನೋಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಚೆಕ್ ಮಾಡಿ
ಆಗಿಲ್ಲ
ಆಗಿದೆ ಅದೇ ಎರಡು ನೋಟಿಸ್ ಆಗುತ್ತೆ ಮೇಡಮ್ ಆಗಿಲ್ಲ ಅಲ್ವಾ that's it.
7, MP Geeta Devi.
Lord, in this matter, R2, my lord, we are not able to track his, though he's in the same address as we're not able to serve notice to him. So I had taken out notice by paper application, my lord, but this
Non taking of paper publication.
order agide, some default on our office.
You have to file another application.
I filed an application for extension of time, my lord. That application, my application has been allowed. The date which has been fixed, I could not take out because I had only short time. I could not take that, my lord. A separate, if lordship may fix another date, my lord, within that date, I'll take out the notification, paper publication.
Are you not required to make another fresh application for me to pass its orders?
No,
I'm
once
just
the
asking.
application is allowed, my lord, so our prayer for substituted service has been allowed. The date fix has
I
lapsed, so fresh date has to be
IA
notified.
2 of 24 లేదా?
My lord, on submission, my lord, the question is, my lord, the allowing of the implementing application filed by the BDA. That is the application between the BDA and the plaintiff, my lord. And the necessity of that, the respondent will may not be arise because there is a rival claim into the suicidal property.
No, to whom it has to be served?
R2, my lord, we are seeking a relief against R1 and 2. And the
Relief,
now-
but the writ petition is filed against them, my lord, the allowing of the implementing application filed by the BDA R7 for implemented BDA as a one of the respond number 7 before.
You have been implemented, no?
Implemented, that order was challenged.
That is impugned before your
That
lordship,
is,
my lord.
the order was challenged.
Let them be there, madam. How do you?
I'll argue on merits, my lord. Let this notice go, my lord. I will argue on merits regarding that
There
application.
is no entry order here, no?
There is a stay of the proceedings.
the
That's what is bothering them. So because this becomes a ground
I
for
I
you to
will just
delay.
not go and take out the publication and then, my lord, we are.
While
we-
we're getting stay application, we'll hear it, that's all.
Regulation, my lord.
I'm telling him. While we're getting stay application. The interim order ಏನಂತ?
No, but the only thing is, my subsequent to that interim order, there is a, it was not extended, I think. I may be right.
ಆಗಿದೆ.
Hearing dates, sir.
On 21/1/2023.
Until further orders ಆಗಿದೆ.
Until further orders.
While they were getting.
You'll have to file a getting stay application. Or on the face of it, show how BDA is not a necessary party, madam.
No, the prayer is sought not against the BDA. If the BDA has an independent claim on the same property, they have to file a fresh suit, my lord.
Page 101, my lord, para 8 of the impugned order.
Where's the impugned order?
Page 100. Impugned order, page 98, well, starts from 98.
Operative portion.
The operative portion, my lord, the 101, the para 8. my lord.
Come to para 8 and 9, madam. How do you overcome this?
I will address this argument, my lord. The court has not, let this notice go, my lord. I'll address this
No, no,
argument.
no,
here.
yeah,
My
that's
lord,
secondary. See, because there is a possibility of,
Your lordship may have it next week, my lord. I will address the argument. If your lordship is not, notice R2 can be dispensed of, then I'll argue the matter on merits next week, my lord. The relief that we have sought is not, a title dispute is not there. We are saying we are the owner of the property, which is, and they claim that my grandfather has given to him.
no, 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 what is the relief in the plain? Where's the plain part?
Plain, my lord, at page 80, 7980 is the plain, my lord, and the prayer is at page 85. Declare the entries made in the revenue records in the property pursuant to the gift deed dated 23/2/2012 as fraudulent, that is by R1 in favor of R2, void and not binding the plaintiff. Declare the gift deed dated so-and-so, the agreement of sale deed are void and not binding. Direction to BBMP revenue authorities cancel and delete the entries made in the records in property in pursuant to the gift deed dated so-and-so. Permanent injunction. The title is not in dispute, my lord. We are saying we are the owners of this property.
They are saying they are the ones with the
They
work.
claim that my great-grandfather has, while the Sadashiv Nagar layout was being formed, there was some understanding and some property has been gifted, has been given to them. That also has not been placed on record. That matter is pending the adjudication before the division bench in writ appeal, my lord. They don't say, they say they are in possession, possessory right is what they are claiming. They say we don't have any title. My grandfather.
What is the document you are claiming a right under?
My lord, kindly see page 91, my lord, para 3, 4 of my application,
Which application?
implementing application. Annexure.
Hmm.
My lord, I submit that the suit schedule property being the palace land measuring 1 acre situated in Upper Palace Orchard was given free of cost to the CITB by the Maharaj of
For
Mysore.
that you should have some document, no? Which is the document?
Well, that we have produced in the evidence stage. Malab, this is only for the implementing application we have produced.
No, show a copy of the document. Why not? Produce a copy of the document. ಅವರು ಹಾಗೆ ಚಾಮುಂಡಿ ಬೆಟ್ಟ ಎಲ್ಲ ಕೇಳಕ್ಕಾಗಲ್ಲ ಅದೇ ರೀತಿ ನೀವುನು ಬೇಗ ಪ್ಯಾಲೇಸ್ ಗ್ರೌಂಡ್ಸ್ ಎಲ್ಲ ಕೇಳಕ್ಕಾಗಲ್ಲ.
And paragraph, there is some portion we have purchased, my lord,
Sir, what are the prima facie documents through which you are making a claim? You are required to produce.
I will get the.
Get it and file an amended application. We'll take it up immediately. I mean,
Yes.
an application for vacating the interim order. In the meanwhile, I'll load this application.
Yes.
Orders on IA 2 of 2024. This court by its order dated 9/7/2024 had permitted the petitioner to serve respondent number 2 by way of substituted service. Full stop. However, petitioner has failed to do so. Full stop. Hence, the present application is made seeking more time to do the needful. More time to do the needful. Full stop. Accepting the cost shown and by imposing a cost of rupees 2,500.
Some error on my side, my lord.
Okay,
we got this there.
If it's advocate's error, I will not order. If it's party's deliberate intention.
The error is on our side, my lord.
Okay. Accepting the cost shown. The application is allowed. Petition, full stop. Petitioner is directed to take out to serve. To
Paper
serve,
application date.
to serve respondent number 2 by way of substituted service. By taking out necessary paper publication in Times of India, English daily newspaper and Vijaya Karnataka, Kannada daily newspaper, Bengaluru edition on or before
13/9, 13/9, 13/9. 4 weeks.
13/9/2024
date of hearing.
And mentioning the next date of hearing as 15 days.
27/9.
27/9/2024. Registry is directed to issue necessary draft paper publication. Post this matter on
27/9.
27/9. ಅಷ್ಟೊಳಗಡೆ ನೀವು ಹಾಕಿ ಅದು ಏನೇನು ಹಾಕ್ತೀರ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಪ್ರೈಮಾ ಫೇಸಿ if it can make out a case, we'll order you to be implemented. It's the question of evidence. Yes.
8. Case Narayan Swami.
For the petition, this case, my lord. Lord, I have filed application for bringing LRs of respondent number 1 and 2, my lord. Notice is already issued, my lord.
ಎಲ್ರೂ ಸರ್ವಿಸ್ ಆಗಿದ್ಯಾ?
R1 LRs, R2 LRs are sir.
ಎಲ್ರಿಗೂ ಹೋಗಿದ್ಯಾ?
Please, my lord.
Yes, ಬನ್ನಿ. Orders on IA 1, 2 and 3 of 2023. The aforementioned IAs are filed to bring the legal representatives of deceased respondent number 1 on record.
Yes, sir.
By condoning the delay and setting aside the abatement. Full stop. It is submitted that respondent number 1 died on
Respondent number died on 1/5/2021, my lord.
1/5/2021. Full stop. In spite of service of notice, the proposed legal representatives have remained absent. Full stop. ಯಾರು ವಕಾಲತ್ ಹಾಕಿಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ ಸರ್.
Accepting the cause shown. The aforementioned IAs are allowed. And petitioner is directed to implead the proposed legal representatives of deceased respondent number 1 as respondents 1A2,
1C, my lord. 1A to 1F, my lord.
1F,
1F.
1F. Next to orders on IA 456 of 2023. Idu same orders agutta. It's for R2. R1 ಇರೋ ಕಡೆ R2 ಆಗುತ್ತೆ. Date of death
5/2/2020, my lord.
5/2/2020.
2020.
2020. ಆಮೇಲೆ 2A2
2A to 2C.
2C ಆಗುತ್ತೆ ಅಷ್ಟೇ. ಮಿಕ್ಕಿದೆಲ್ಲ ಸೇಮ್. ಎಸ್.
9. Pradeep SB.
ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಅಂತಲ್ರಿ? ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಅಂತ
ಅಲ್ಲ ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಸರ್ವಾಗಿಲ್ಲ ಪ್ಲೀಸ್.
FDP ನ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ, ನೀವು ಒದ್ದಾಡೋದು?
ಡಿಸ್ಪೋಸ್ ಆಗಿಲ್ಲ ಮೇಡಮ್, ಅದರಲ್ಲಿ ಕ್ಲೋಸ್ ಮಾಡಿದ್ದಾರೆ ಸುಮ್ಮನೆ FDP ನ. Still one minute. We have filed memo, my lord, on 7/9/2022, my lord.
ಇನ್ನೇನಂತ? What is the order and challenge, sir?
Lord, I have challenged the order.
If you have challenged, appa. What is the next F?
I have filed an application before the FDP court, my lord, for appointment of court commissioner, my lord. Then the respondent number 1 herein, my lord, filed an objection before the trial court, my lord. Upon that, considering that objection, my lord, the FDP court passed an impugned order, my lord. That order has been challenged before this honorable court, my lord.
Even for further steps of appointment of court commissioner ಅಂತ ಇದೆ.
Wherefore, in view of the memo and the pendency before the WP Honorable High Court of Karnataka, the present petition is closed ಅಂತ ಮಾಡಿದ್ರು ಸಮಯಲ್ಲಿ FDP court. ಇಲ್ಲಿ ಪೆಂಡೆನ್ಸಿ ಇರೋದ್ರಿಂದ ಅದು ತುಂಬಾ ದಿವಸ ಹೋಯ್ತು ಅಂತೇಳಿ ಪೆಂಡೆನ್ಸಿ ಕ್ಲೋಸ್ ಮಾಡಿದ್ರು.
My lord, during the pendency of this writ petition, my lord, FDP is closed, my lord. For that reason, my lord, notice is not served in respect of R4, my lord. My lord, I have filed a suit for partition in respect of suit schedule property, my lord.
The same is decreed.
Please, my
lord. You are entitled
I have
for
filed an FDP, my lord.
1/5 share ಅಂತ ಆರ್ಡರ್ ಆಯ್ತು.
Please, my lord.
Then you filed for FDP.
Please.
FDP ನಲ್ಲಿ for the further steps and appointment of court commissioner ಅಂತ ಆರ್ಡರ್ ಆಯ್ತು.
Please.
ಎಂತ ಆರ್ಡರ್ ಅಲ್ಲಿ
But the FDP court is committed the error, my lord. Without application of mind, the FDP court said that, my lord, I am not the co-partner. I am only
Entitled for
notional
notional
benefit of
partition.
the father property.
Who are you?
I am the co-partner of, I am the daughter of the Rajshekhar, one of the.
Karta of the
Karta.
family. I am
Lord,
also one of the.
You are a daughter of Rajshekharapan, huh?
Yes, my lord.
When did your father die?
During the year 2001, my lord.
Huh?
2001, my lord.
You are married yavaga?
1993.
my lord.
You are married in the year 83, huh?
Yes, my lord.
So
1993.
Karnataka amendment will not help you. You have to fall back on Vinita Sharma.
Lord,
You have to fall back on Vinita Sharma.
Yes, ma'am.
Vinita Sharma.
Vinita Sharma.
Please, madam.
ಅಲ್ವಾ?
ಹೌದು.
ಇವಾಗ ಏನಂತ ಕ್ಲೋಸ್
I'm
ಆಗಿದೆ?
also-
Where is the final order?
Annex F, my lord. Page number 62, my lord. 62 ಅಲ್ಲ?
No.
65.
Final order ಅಪ್ಪ. See, this order says whatever the court decided. It said for further steps and appointment of court commissioner
Yes, my lord.
to determine your 1/15th share. He is telling, court is telling you are entitled to 1/15th share.
1/5 share.
1/5 share, my lord, not 1/15.
1/15th re order ನೋಡಿ. Page number 67 ನೋಡಿ.
Fifth share.
Daughters will be getting 1/15th share ಅಂತ court has held.
Yes, ma'am.
Appointment of court commissioner ಆಗುತ್ತಾ? Now FDP close ಆಗಿದ್ರೆ should you not be challenging the entire FDP proceedings?
No, my lord, we are not challenging the FDP proceedings, my lord. Only we are challenging the interim order, my lord.
Interim order. Pass or
ಈಗ ಏನಂತ ಕ್ಲೋಸ್ ಆಗಿದೆ? ಆರ್ಡರ್ ಕಾಪಿ ಕೊಡಿ.
My lord, order is, my lord, page number 65, my lord.
ಅದಲ್ಲಪ್ಪ, ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಆಗಿದೆಲ್ಲ ನಮ್ಮ ರೆಕಾರ್ಡ್ಸ್ ಪ್ರಕಾರ 8/8/2022 there is an order. ನೀವು ಅಪ್ ಟು ಡೇಟ್ ಆಗಿ ಬರ್ದಲ್ಲ ಇದ್ರೆ ನಾವೇನ್ ಮಾಡಕ್ಕಾಗತ್ತಾ? ಇಲ್ಲ ತೆಗ್ಸಿ. ಇಂಟ್ರಿ ಮಾಡರ್ ಇಲ್ವಾ ಇದ್ರಲ್ಲಿ?
Interim order ಇಲ್ಲ sir.
ನಾಟ್ ಟು ಡ್ರಾ ಫೈನಲ್ ಡಿಗ್ರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಂತ ಇಲ್ಲ.
Earlier advocate not attend the court, my lord. The writ petition is dismissed for non-prosecution, my lord. Thereafter, the.
ಈಗ ಫೈನಲ್ ಆರ್ಡರ್ ಆಗಿದೆ FDP ನಲ್ಲಿ. That's what our records are revealing. ನೀವು ಅಪ್ಡೇಟ್ ಆಗಿ ಬರ್ಬೇಕು.
My lord, last line, my lord. Only in respect of R4, my lord, I have taken substituted of service, my lord. I have already filed IA, my lord.
ಎಷ್ಟು ಸಲ ಹೋಗಿ ಬಂದಿದಪ್ಪ?
R4
R3 and 5.
R4, 3 and 5 served, sir.
Served,
Yes, my lord.
ಏನಾಗ್ಬೇಕು ಈಗ?
R4 ಗೆ ಮಾತ್ರ substituted service, my lord. I may be permitted to take
Paper public.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ?
Already filed, my lord.
I filed, my lord.
ಯಾರಿಗೆ ಹಾಕಿದಾರೆ?
R4
Yes, ma'am.
application ಹಾಕಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ ತೋರಿಸಿ.
That IA may be allowed, my lord.
ಎಷ್ಟು ಸಲ ಹೋಗಿ ಬಂದಿದೆ?
IA 2, my lord.
R4 ಗೆ.
ಎಷ್ಟು ಸಲ ಹೋಗಿ ಬಂದಿದ್ದಾರೆ?
Yes, Nataraj.
Three times.
ಅಡ್ರೆಸ್ ಯಾವ್ದವ್ರು?
Nataraj, son of Dave.
ಅಲ್ರಿ, how can we order three and five ಹೋಗಿ ಇದೇನಾಗಿದೆ ಸರ್ಡ?
3 and 5, sir.
ಬನ್ನಿ. On the ground that in spite of taking steps several times to serve respondent number 4, the same has remained the attempt has remained unsuccessful as respondent number 4 is deliberately avoiding the court summons. The aforementioned IA is filed. The orders on IA 2/2024 of that. The aforementioned IA is filed with a prayer to take out, to serve respondent number 4 by way of substituted service. By taking out necessary paper publication in Kannada daily newspaper, Kannada Prabha, Bengaluru edition.
Please, my lord.
Full stop.
Please.
Further, though the application is made in respect of substitute service, though the application is made for taking out substituted service to respondent number 3 and 5 also,
Yes.
The same is not pressed as 3 and 5, respondent number 3 and 5 are served. Are already served. Full stop. Next para. Accepting the cost shown, IA 2/22 is hereby allowed insofar as it relates to taking out, insofar as it relates to serving respondent number 2, respondent number 4 by way of substituted service as prayed for. Full stop. Hence the following order. Petitioner is permitted to serve respondent number 4 by way of substituted service by taking out necessary paper publication in Kannada
Prabha.
daily newspaper, Kannada Prabha, Bengaluru edition,
Please.
on or before
39.
2024 with next date of hearing shown as 27/9/2024.
Please.
Full stop. Registry is directed to issue necessary draft paper publication and also full stop. Call on 27/9.
Please. Grateful.
Number 10. Ravi Prakash V. DP Mahesh.
Before the petitioner, my lords. My lords, plaintiff's writ petition. An application was filed under 6 Rule 17 for amendment, my lords. Amendment to mention the correct survey numbers and the schedule. My lords, may kindly see the application.
Respondent is last time ಬಂದಿಯಾರ ನೋಡಿ respondent.
Last occasion, the matter was listed for, I was not carried out the amendment, my lords. It was.
ಆಯ್ತು, ಅವ್ರ ಒಂದು ಡೇಟ್ ಕೊಡೋಣ. Advocate for the petitioner present, advocate for respondent absent, call on.
30th, 30.
Interim order may kindly be accepted.
Interim order if any is extended till next date of hearing.
Serial number 11, Chandranath Tariga K. Ravishankar.
For the respondent.
Ready, all both sides?
I'm ready. And the statement of objection is ready, Your Honor. I have served to.
ಆಯ್ತು, ಆಫೀಸಲ್ಲಿ ಹಾಕಿ.
ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಆಯ್ತು, at the request of.
2016 matter.
Last.
All right, sir, at the request of respondent, call on. 15 ದಿವಸ ಬಿಟ್ಟು ಡೇಟ್ ತಗೊಳ್ಳಿ.
Please.
On that day, argue the matter and close.
ಆಯ್ತು.
5-9.
Fine.
Please.
Yes.
9. Serial number 12, Vyasrao KS. Serial number 12,
Yasra has some inconvenience, my lord.
The request of petitioner, call on, date ಕೊಡಿ.
28. 13, VB Shivkumar. Serial number 13,
Before petitioners, my lords, kindly grant one short accommodation.
What is this, madam?
A week's time may kindly be granted, my lords.
Date ಕೊಡಿ, at the request of petitioner, call on.
30th.
Oblige, my lords.
14, Banu Prasad. K. Respondent, sir, Tantra present.
ಏನು ಉಳ್ಕೊಳ್ತಾ ಇದ್ದು? ಸರ್ವಿಸ್? None appears with the petitioner. Call on, date ಕೊಡಿ. ಏನಾಯ್ತು? None appears with the petitioner on last 2 dates of occasion also. On last 2 dates of hearing also. None appeared for the petitioner. Full stop. The writ petition is of the year 2017. It appears petitioner is not interested in prosecuting the writ petition. Writ petition dismissed for non-prosecution.
C15, Jagdish Gowda Patil, KP Bhuvan.
Appearing for respondent, respondent number 3.
What about petitioner?
Last time, request of 11% of the petitioners.
None appear for the petitioner. Finally, call on date ತಗೊಳ್ಳಿ. Cause ಬಂದಿಲ್ಲ ಅಂದ್ರೆ dismiss ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ.
28, 28.
28 ಹಾಕ್ಬೋದಾ ಸಿದ್ದರಾಮಯ್ಯ?
ಆಗ್ಬೋದು ಸರ್.
28.
Kennedy except 22.
28.
28, 28.
ಆಗ್ಬೋದು.
16, 17, Ajahn. 18, Vishwajit Rai. HV Devaraju.
I appear for the petitioner, my lord. Annexure A is the impugned order, my lord. Now, if your lordship may kindly peruse annexure B for a moment, my lord.
Ready na?
I'm ready. Annexure B of Metao. It is at page 20, my lord.
You're challenging annexure ಏನ sir?
ಇಲ್ಲ, annexure is the impugned order. Just for a moment, my lord, annexure B may kindly be seen. I had filed a suit, my lord, in OS number 63 of 2014, which came to be decreed, my lord. Now, the decree, my lord, is restraining the respondents from interfering with the suit schedule properties. Now, thereafter, my lord, the respondent number 1 and 2, my lord, didn't obey the orders passed as per the decree. I filed execution, my lord. Meanwhile, my lord, after a lapse of 4 years, my lord, the respondent 1 and 2 files miscellaneous case to recall the judgment. Yes, that there is a delay of 4 years in filing the petition. That miscellaneous case is pending, no order has been passed. In my execution petition, my lord, he files an application to stay the proceedings in MFA, my lord. That could not have been done. If at all he was agreed, my lord, he should have filed an application before the miscellaneous case itself. He can't file an application for stay in my execution petition.
Yes.
That I am.
He is
for
not
the 3 and 4. I am not a party in the original suit. Even in the execution case,
They are not-
where they have been implemented me as an respondent.
They are not, I am not seeking.
Last time,
For-
you are not a respondent.
They have served
Served and unrepresented.
Servant and underrepresented.
unrepresented.
ಅವರ ಮೇಲೆ ನಮ್ದೇನಿಲ್ಲ, actually, their formal party ಮೇಲೆ. My submission.
1 and 2 unrepresented,
P and 4.
But in the miscellaneous petition, my lord, they go on taking time, my lord.
I am in the miscellaneous also I am not a party.
Yes, my lord, he is only a form, because they were in the suit ಅಲ್ಲಿ party ಇದೆ ಅಂತ they are made.
ಸೂಟಲ್ಲಿ ನಾವು ಪಾರ್ಟಿ ಇಲ್ಲ.
3 and 4 ಬನ್ನಿ.
Original suit also we are not parties.
Agreed by the order passed in passed on IA number 3. Dated so and so in execution case number 17 of 2017 by so and so. The petitioner therein has preferred this writ petition. Full stop. The petitioner has obtained judgment and decree allida.
ಹೌದು, annexure B, my lord, decree copy produce ಮಾಡಿದ್ದೇನೆ.
Annexure
B. 1st September 2000.
Why you made 3 and 4
ಯಾಕಂತ?
party here, sir?
ಅದು ಯಾಕಂತ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. Anyhow, no relief is claimed against them at all.
That where did the execution court, they have been implemented me as a respondent 3 and 4. Though we are not a party to the original suit.
I'll observe that.
Yes, ma'am, your lordship.
Then month ಹೇಳಿ. So and so and the petitioner has obtained, petitioner has obtained better. Petitioner filed OS number 63 of 2014 against respondent number 1 and 2 herein, and has obtained a decree as follows. ಇದು page number 21 ಅಲ್ಲಿ ಇದಿಷ್ಟಿದೆ ನೋಡಿ, ಇಷ್ಟು ಮಾತ್ರ extra. Page number 21 as follows. Full stop. Next para. On the ground that respondent number 1 and 2 have violated the impugned order, execution case number 17 of 2017 on the file of so and so has been filed by the petitioner herein.
Annexure C is the execution petition, ma'am.
Full stop. In the said execution petition, respondent number 3 and 4 are also made parties. Full stop. The petitioner, however, submits.
Well, what I said in the execution, they are now trying to give electricity connection to the petition schedule
That is
premise.
different, sir.
Okay, that's all. I leave it to the court.
However, submits that no relief is claimed as against respondent number 3 and 4. Full stop. Next para. In execution case number 17 of 2017, respondent number 1 and 2 have filed respondent number 1 and 2 here have filed IA number 3. IA number 3 ಎಲ್ಲಿದೆ?
ಹೌದು, I number.
ಇದೆ.
ಇಲ್ಲ, annexure D, my lord.
Annexure
D,
D,
page 27.
and method sentence. Under section 151 CPC with a prayer to stay further proceedings in the execution petition, comma, on the ground that they have filed miscellaneous case number 7 of 2017, challenging the order passed in
OS number 63 of 2014.
OS number. ಹೈಕೋರ್ಟಲ್ಲಿ ಹಾಕಿದಾರ?
ಇಲ್ಲ ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ miscellaneous case.
That is ex parte decree that seeks for set aside. the ex
ಇಲ್ಲ ಹೈಕೋರ್ಟ್ ಅಂತ ಬರೀತಾರೆ ಮತ್ತೆ honorable court. Okay.
Honorable court deemed fit.
In OS number 63 of 2014. 63 of 2014. Full stop. It is submitted that ಏನಾಗಿದೆ ಈಗ 63 of
Pending ಇದೆ. This miscellaneous case was filed after 4 years.
no, see, miscellaneous case ಇನ್ನ pending ಇದೆಯಾ?
How this pending it? I inquired today, man. Because in view of this.
Also.
Yes.
The execution court on the ground that it is submitted for that. The execution court on the ground that the miscellaneous case could become infructuous if the decree is executed, has passed the impugned order, staying the proceedings in the execution petition. Full stop. Agreed by the same, the presented petition is filed. Next para. In spite of service of notice, the advocate for respondent number 1 and 2 is absent. Next para. It is submitted by the petitioner that a decree has been passed in his favor in OS number
63 of 2014.
63 of 2014 and execution case number 17 of 2017 has been filed to have the said decree executed. Full stop. It is submitted that though miscellaneous case number 7 of 2017 has been filed, no interim order has been passed staying the operation of the judgment and decree passed in OS number so and so.
Delay itself was not condoned. Alla adu yakendre.
It's okay, that's immaterial over here. OS number so and so. Full stop. It is further submitted, under the circumstances, the execution court cannot go beyond the decree and it should not have stayed the proceedings in execution case number so and so. Full stop. Next para. Admittedly, OS number so and so has been decreed in favor of the petitioner herein. Full stop. The same has not been stayed. The said judgment decree has not been stayed in miscellaneous number so and so. Full stop. Executing court cannot go beyond the decree. Full stop. In the absence of any stay granted on the operation of the judgment and decree passed in OS number so and so, the execution court ought not to have stayed further proceedings in execution case number so and so. Full stop. For the aforementioned reasons, the following order is passed. The impugned order passed on IA number 3 in execution case number so and so, dated so and so, by so and so, is hereby set aside. IA number 3, next to IA number 3, filed by respondent number 1 and 2 in execution case number so and so, is hereby dismissed. Next, the executing court is directed to proceed in execution case number 17 of 2017 in accordance with law.
Grateful.
Against R3 and 4 is concerned, we are not a party to the original suit itself.
Sir, I have observed no relief is claimed against you.
19, Manmohan PN.
For R2 minutes.
So last occasion, my lords, I took time in this matter on the ground that, my lords, on 25th of January 2024, there is a specific order, my lords, saying that there is an RFA pending between the same parties. My lords, so that matter has to be disposed of because that order, the judgment in the RFA will be having a bearing on the simple ground that, my lords, the suit for partition came to be, my lords, partly dismissed, against which RFA is pending. Now the, my own, my lords, partner who sold the property, one of the share of the property.
You want time now?
My lord, they are seeking time. They intimated us that
I'm
they would
asking
be
him only,
seeking.
you want time?
Yes, I have moved that matter.
You
for
have any
earlier.
problems?
No objection.
Right.
A date
The
might be
request of
fixed, my
petitioner,
lords.
call on date togoli.
Minutes, and that matter is next posted on 2nd minutes. I had requested the honorable judge. So can it be after 2nd minutes? Because it's a division bench matter.
9:30.
9.
Obliged.
Grateful.
20.
You get necessary instructions, madam.
I shall.
Should pendency of it come in the way of these proceedings, argument surely.
I
Please,
shall.
minutes, I had the benefit of interim order till today minutes, which.
Interim order if any is extended till next date of it.
Obliged.
Number 20.
That might be attached.
Obliged.
Here, Ramesh Babu. MK Shivraju. 20.
The impugned order,
MK Shivraju.
the order impugned, my lords, is an order impounding so the trial.
Shivraju, sir.
They not appeared on the last date of hearing as well.
One date pona, Bandel Andre will decide. Advocate for the petitioner present, none appears for respondent, call on. Not this date kudi, Monday kudi,
Monday.
Tuesday,
27.
27th.
Please. That's the interim order, kindly.
Interim order if any is extended till next date of it.